Nào, chết được. Hello.
May I have Lordship? Yes. Lordship, I beg to mention item number 41 to 44. 41 to 44, Lordship. Here I'm for the appellant.
Excellent.
41 to 44. Lordship, let this matter come up for 3 weeks, Lordship.
So you have informed the respondent.
Yes.
Yes, Your Lordship.
No objection. No. On the joint prayer made by the land council for the appellants. Sorry, made by both the land council for the parties. This is made after
3 weeks, Lordship.
3 weeks. Okay.
English, my lord.
May I please, my lord?
Mm.
Lordship, I beg to mention item number 4. Item 4, my lord. Lordship, in this matter, I am appearing for respondent number 1. Lordship, the decisions of the committee is yet to be received by us, your lordship.
Committee regarding what?
Lordship, a
Okay.
committee has been constituted to look into the minimum scale of pay of the, yes, your lordship, and the decision of the committee is yet to be received by us, your lordship. So if
Whether the petitioner is present?
lordship, in fact, I have looked for them in court number 1 also. I did not saw any one of them, your lordship.
So then let the matter be called to that. When the matter comes up, if they are not present,
Lordship.
we'll adjourn accordingly. So we can't record their absence at the moment.
Lordship,
Okay.
lordship.
May I please the lordship?
Yes.
Lordship, I beg to mention hearing item number 32, 33, and 34, lordship. Lordship, here I'm for the state respondent, lordship. If lordship may please to list the matter after 3 weeks, lordship.
You're
Since
for-
I'm for the state respondent, lordship.
So the petitioner is present.
Lordship, lordship.
No objection.
No objection. Miss
बेटा ते
Direct Counsel for the petitioner is present. Mr. Jimomi, appearing on behalf of the state respondent, prays for adjournment with the matter for
3 weeks, lordship.
3 weeks. Prayer not objected. Accordingly, list this matter after 3 weeks.
Lordship, I also have a similar prayer for item 39, lordship.
Item
39 of the
39.
hearing list, lordship.
Yes.
Lordship, here, this matter has been recently endorsed to me, lordship. So I have to go through the brief of the matter, lordship. So if lordship may please to grant 2 weeks
Mr.
time. No objection. In the noction.
Counsel for the petitioner is present. Mr. Jimomi would appears on behalf of the respondent.
Lordship, on behalf of the respondent.
Okay. And prays for some time to go through the records
Lordship.
and to obtain necessary instruction stuff. The prayer is allowed. List this matter after
After 3 weeks, lordship.
3 weeks.
Lordship.
One thanks.
Lordship, I also have a prayer for item 36 to 38, lordship. Lordship, in this matter, lordship,
Hmm.
this honorable court has directed the state respondent, more particularly the Deputy Commissioner Dimapur, to get a necessary instruction as to whether the pata has been cancelled with regard to the one petitioner, Bendam Marin, lordship. Lordship, however, till such time, I'm yet to receive instruction, lordship. So if
Whether the
lordship,
petitioner is present.
item 36 to lordship, but I have informed the
Okay.
opposite
Mr.
parties,
Jimomi,
lordship.
with the consent of the land counsel for the petitioner, prays for
2 weeks time.
3 weeks time to obtain necessary instruction from his client. Okay. From the deputy commissioner.
From the Deputy Commissioner Dimapur,
The prayer is allowed. List this matter after 3 weeks.
lordship.
Okay.
Lordship, I have similar item number 9, lordship. Like to mention item number 9, lordship. Lordship, here the state respondent is yet to file affidavit in opposition, lordship.
Lordship, I have a short prayer, Lordship. In this matter, Lordship, the counsel engaged for the state respondent is Ms. Livika. And she has been on leave for quite some time, Lordship. If she's going to take more time, Lordship, if somebody else can take up the matter, since the matter is a simple matter and the issue pertains to salary, Lordship. Now the petitioner is drawing salary less than the salary.
Lordship, in fact, in this matter, the leading counsel, she must have engaged one of her colleague to appear. So lordship, we will do the needful and then in the meantime, we will file our affidavit in opposition.
Mr.
Lordship.
Land counsel for the petitioner is present. Mr. Jimomi appearing on behalf of Ms.
Livika, lordship.
Livika,
Lord.
land counsel for the state respondent. Prays for
3 weeks time, lordship, to
prays
file
on
affidavit.
behalf of- Yes, sir, prays on her behalf for 3 weeks time to file affidavit
In opposition.
in opposition. Take it up. List this matter after 3 weeks. Okay.
Obliged, Lordship.
Lordship, I beg to mention item number 7, Lordship.
Yes.
Lordship, I'm appealing on behalf of the petitioner, Lordship.
Okay. Yes.
Lordship, the talks between the parties are still going on, and I'm praying for adjournment, Lordship, for 4 weeks.
What is going on?
Settlement talks between the parties.
Okay. Mr.
Rajesh Kumar.
Land Council, Rajesh Kumar, Land Council for the petitioner, submits the settlement of the case between the parties are going on and pray for adjournment of the case for the week. So, prayer.
Lordship, kindly allow, kindly interim stay be allowed, Lordship.
Interim
Interim is, yeah, Lordship. Interim will continue, Lordship.
prayer is allowed. List is matter after how much time?
4 weeks, Lordship. 4 weeks, 4 weeks.
Stop. The interim order pass earlier will continue till the next stage. Okay. Yes.
Thank you, Lordship.
I'm appearing on behalf of responded myself.
Okay.
Item 7,
Yeah, your name
Indian auction.
is name also. Okay. Correspondent, huh? Okay. Yes.
Thank you, Lordship. Lordship, I'd like to mention hearing item number B6 and 7.
Yes.
Lordship, here, in compliance with the order dated 3/6/24, we have filed the amended appeal memo. And I have furnished the copies to the respondent only this morning. So let this matter be fixed for hearing after 2 weeks.
Okay. Miss Land Council for the petition submits that they have filed the amended post title or petition.
We have
Amended petition.
I'm in the petition, Lordship. I received
And
this morning.
serve the copy to the. Land
In both
Council
the
for
matters.
Respondent. Mr. Procedure for the Land Council for the respondents
Lordship.
has received the copy
Lordship.
on the prayer of both the Land Council for the party. This is matter after
3 weeks, Lordship.
3 weeks. Okay.
Lordship.
May I please, your Lordship?
Yes.
Lordship, I beg to mention item number 18 of today's orders column, Lordship. Lordship, on the last occasion, Lordship, your Lordship has directed the registry to list the item in the, hearing list, Lordship. It was already
Oh, this was to be listed as.
in the hearing column.
I
So
think
my,
order it was written hearing only, I think. So it has been listed as in order.
in order,
What do you
Lordship.
want? It is
Lordship, it may
listed
be, it may come up in the hearing list today, Lordship.
hearing.
Lordship.
When?
Today, Lordship. It is fixed today. It is a fixed matter today.
Okay. Okay, let the matter come.
Lordship, obliged, Lordship.
Right.
Lordship, I also beg to mention item number 3 on behalf of Mr. A.K. Mishra, Lordship.
Okay.
Lordship, due to the present road condition, Lordship, he could not reach High Court on time. And he asked me to pray before this honorable court to list the matter after 3 weeks.
Okay. This is only for the condemnation petition only.
Lordship,
Notice was to be issued.
Lordship.
Okay. Mr. Appearing on behalf of
Mr. A.K.
His
Mishra,
name is also there, not there. A.K. Mishra.
Lordship.
Oh, some said Mr. A.K. Mishra, who is appearing in the case, could not make. Okay, could not appear at court due to the road condition, present road condition, and prays for adjournment. Prayer allowed. List is when he wanted.
Lordship, after 3 weeks.
List matter. After 3 weeks, it's prayed for. Okay.
Highly.
Lordship, I may be allowed to make a mention for item 17. I may be granted 3 weeks to file my affidavit in opposition. I am for the private respondent.
Who is for the petition? Is present? Is the petitioner present?
Yes.
Okay. Miss,
Kelly Lisu.
Land Council for the petitioner is present. So, Mr. Santiago appearing on behalf of respondent number,
Is it 5 or 6?
on behalf of the
The private respondent, Lordship.
private
Respondent number 5.
prays for how much time you said?
3 weeks, Lordship.
Prays for further 3 weeks time to file affidavit. in opposition. The prayer not objected. Accordingly, the prayer is granted. List is met after 3 weeks.
Much obliged, Lord.
Prayer is allowed.
Lordship, in item 25, Lordship,
Hmm.
here I am challenging the selection process. And I am to implement those private respondents whose appointment I am challenging, Lordship. However, I am yet to receive information regarding one person whose roll number is 300000810. Because of that, I have obtained information for 67 others, Lordship, but because of that, I am unable to file my interlocutory application because even without that single person, this petition cannot move ahead. So if it can kindly be listed after 3 weeks, Lordship.
Mr. Sentient Garland Council for the petitioner submits that in the instant application, he wants to file IA for improvement of the private respondent.
Yes, my lord.
However, private respondent and prays for some more time.
2 weeks, Lordship.
So further 3 weeks times, the prayer is allowed. List is met after 3 weeks.
Much obliged, Lordship.
Okay.
May I please, my lord?
Yes.
Lordship, item number 4.
Yes.
Lordship, may kindly grant us three weeks time to get the necessary instruction, my lord.
Okay. The petition.
Lordship.
Okay. Yeah, Mr.
Benison Bishop.
Okay. Land Council for the petitioner is present. Mr. Anangami appearing on behalf of respondent number 1.
1, my lord.
Praise for the, how much time?
3 weeks time, my lord.
No. Sukri, you are also praying?
It's about 2 to 5.
Okay. Miss V. Sukri, an additional AG appearing on behalf of respondent number 2 to 5, and Mr. Anangami appearing on behalf for respondent number 1. Praise for further 3 weeks time to file affidavit.
To receive instruction,
To
lordship.
receive, to obtain instructions. The prayer is allowed. List is made after 3 weeks. Okay.
Deeply obliged, my lord.
May I please, your lordship? I beg to mention item number 35.
Item?
35.
Yes.
Your lordship may kindly list this matter after 2 weeks.
Why?
Personal difficulties, your lordship.
You're for the petitioner.
Yes, your lord. I'm for the respondent number 4.
Okay. Who is for the petitioner? Informed.
Yes, your lordship.
Yes, your lordship.
Okay.
With consent.
Mr.
Benison Bishop.
Land Council appearing on behalf of the respondent, submits that he has some personal difficulties today and prays for adjournment, to which the Land Council for the petitioner has no objection. Is prayed for, list is made after
2 weeks.
2 weeks. Okay.
Obliged you.
May I please, your lordship?
Yes.
Your lordship, I beg to mention item number 10 and 11. Here state is yet to receive affidavit. State is yet to file affidavit in opposition, your lordship. So kindly grant me 3 weeks time.
Objection, lordship.
Mr. S1, Land Council for the petitioner is present. Miss,
AIME.
appearing on behalf of the respondent. Prays for further
3 weeks, your
3
lordship.
weeks time to obtain instruction and to file affidavit.
Yes, your lordship.
To affidavit. The prayer is allowed. List is met after 3 weeks. 10 and 11 separate. Similar order. Yes.
Your lordship, I beg to mention item number 40. Here, 40. I'm yet to receive the reply filed by the petitioners, your lordship. I've been informed that they'll be serving the copy to me today. So let the matter come up after a week.
Okay, Miss. Okay. Land Council for the petitioner is present and her, Miss Swenson. Submit said she is yet to receive the affidavit in reply filed by the petitioner. Until then, the matter may come up after. And for the above region, the matter may come up after
1 week, your lordship.
a week. You serve copy then?
Yes, lordship.
Okay, Miss So-and-so shall serve copy of the affidavit in reply filed by the petitioner staff as prayed for by the Lion Council for the party. List is matter after a week. Okay.
Okay, may I please, your lordship?
Hmm.
I beg to mention hearing item number 29. Kindly allow this matter to be listed after 3 weeks, lordship. Hearing item number 29.
You are for?
I'm for the petitioner.
Okay. You are for?
Respondent number 1.
Private respondent?
Yes, your lordship.
Okay, Miss Lion Council for the petitioner. Praise for listing this matter after 3 weeks, to which the Lion Council for the respondent has no objection. The prayer allowed, list this matter after 3 weeks. Okay.
May I please, your lordship?
Hmm.
Your lordship, I beg to mention item number 32, 33, and 34.
Yes,
Kindly let the matter,
they already adjourned.
okay, much obliged, your lordship.
May I please, your lordship, I beg to mention item number 13. My senior TB Jamir is having some personal difficulties today, so let the matter come up after 2 weeks for admission hearing. I'm for
Yeah.
respondent 3, 6, and 7.
I'm for the appellant, lordship. I have no objection.
Okay, Mr. Pasego for the Lion Council for the appellant is present. Miss
Tiruchila Jamir,
Sam is that the conducting council, who is
TB Jamir.
Lion Council for the respondent has some personal difficulties today, and pray for adjournment of the matter. The prayer not objected, staff. Has prayed, comma, list is matter after
2 weeks.
2 weeks. Okay.
Obliged, my lord.
May I please, your lordship,
Yeah.
I beg to mention item 8. Here, we have received an additional affidavit filed by the state. However, we want to file objection, so 2 weeks time may be given.
Miss Bahar, please.
Oh, it's okay.
And Miss Mary Lana. Council appearing on behalf of the state respondent. Okay, state council, start. Miss so submits that she had just received the additional affidavit filed by the state respondent and prays for some time to go through and to go through the same stuff. The prayer is allowed. List is met after
3 weeks, lordship.
3 weeks. Okay.
Lordship, I also beg to mention item 28, hearing item 28.
Hmm?
28, hearing item 28. I'm for the private respondent. The leading counsel has some difficulty, so if it may be listed after 3 weeks.
We inform the
It- Lordship,
council.
Yes, lordship.
I'm for the petitioner,
Okay,
appearing on behalf of Ajo.
Miss
Kayakula,
is present on behalf of Mr. A. Joe Lana, council for the
petition.
appellant. Staff, Miss
It's a great. lordship.
submits that the conducting council, Mr. City Jamil,
Yes, lordship.
Lana Senior Council, the City Jamil Lana Senior Advocate for the appellants, council for appellant has some difficulties today.
Council
Prays for
respondent.
adjournment. Sorry, respondent number
1.
has some difficulties today and prays for adjournment. Prayer not objected. Yes, adjourn. List is matter after
3 weeks, lordship.
3 weeks.
Obliged, lordship.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 14 and 15 on behalf of Ajo.
Lordship, here I am appearing for the respondents. In fact, the interim prayer for stay, they are having an interim order in their favor.
Okay,
So that was to be taken up.
today.
Yes.
Uh,
Because on the last occasion, for some reason I could not be present. Lordship will kindly produce the last order.
So let the matters be called for then.
Lordship, my senior is not here. He has some personal difficulty.
Who is your senior?
Ajo,
A. Joe.
yes, your
Okay,
lordship.
petitioner.
Yes, your lordship.
If it is not inconvenient, our senior is not keeping well. Let a short date be given, Lordship, but
Okay.
for consideration of the,
Miss
Kayakula,
submits that the conducting council, Mr. A. Joe, Lana Council for the petition, has some difficulties today and prays for adjournment. Mr. R.K.D. Chaudhary, land counsel for the respondent is also present. So, as prayed for by the land counsel for the parties. List is matter on.
After a week,
After 3 weeks.
no, Lordship, they are on,
Okay.
they are enjoying an interim order.
Okay. So they.
After a week, Lordship.
Huh?
After a week, Lordship.
After a week. So you wanted the date to be fixed
Yes, Lordship.
after a week.
After a week, Lordship. I file my objections, Lordship, that can be taken up, Lordship, and the matter can be disposed of.
Okay. Hmm? Just a minute. September would be, say, 19,
10th September.
10 September.
I'm so honest.
Okay.
Only because he's not
By
keeping
land
them,
counsel.
Lordship.
This matter on pen, huh?
Lordship, there is interim and continue.
Okay, stop.
Till that date, Lordship.
The interim order passed earlier shall continue till the next date. Yes.
Please, your lordship, I'd like to mention item number 16. 3 weeks time, I'm granted to file my written reply.
Affidavit in reply. Okay. Mr.
Nang sangaya.
Land counsel for the petitioner prays for 3 weeks time to file submits that he has received an affidavit in opposition filed by the respondent and prays for 3 weeks time to file affidavit in opposition. The prayer is allowed. List is matter after 3 weeks. Okay. He's present. Huh? Mr. Mohammed is present. Be record. Let's record. Okay.
May I please, your lordship?
Yes.
I'd like to mention item number 21. Your lordship, by order dated 30/7/2024, we were directed to take dusty service upon respondent 9. Your lordship, kindly grant us 3 weeks time to file the affidavit.
Miss
And so,
2021.
21, your lordship.
Land counsel for the petitioner submits that although she has taken steps upon the respondent by dusty service, however, prays for some more time to file affidavit to that effect. The prayer is allowed.
Lordship, I have no objections. Lordship, if my presence may kindly be reflected, I am appearing for respondents 1, 2, and 3.
Prayer not objected to by Saint Young Land counsel for the respondent number 1, 2, and 3. Stop. As prayed, list is matter after 3 weeks. Okay.
Much obliged.
So we're back to mention item number 24, Lordship.
Yes.
Also have instruction to appear on behalf of respondent number 6, Lordship.
Okay. So the petitioner, you are appearing for the first time.
Yes, Lordship.
Okay. So you want some time to,
Get instruction, Lordship.
okay. So respondent number 6 is appearing for the first time, praying for some more time. You receive the copy. You have,
Lordship. Yes, Lordship. I have.
okay. You have any objection?
No objection.
Okay,
Lordship.
Miss. Our name, huh? Land counsel for the petitioner is present. Stop.
No, these.
Mr. Angam, you are for?
4 and 5, lordship.
Okay, and who else is appearing for the other respondent? Are you also appearing? Are you also?
And for respondent number 2.
Earlier you already appeared.
No, my lord, this is my first.
Okay, Mr.
I have not received that.
Okay. Okay, you serve copy then?
Yes, Lordship.
Okay, Mr.
That only, my lord.
Would appear on behalf of respondent number 4 and Mr. Moazami for respondent
Apology, I think that's a mistake with my
6.
post list, lordship. Or
This is 24.
24, but
You are not appearing here.
24 will.
He is mentioning the 24. 24.
Yes, Lord.
other, no? Other.
Okay, 24, 6, and submits that you have received, you have not yet received the
Yes,
copy.
my lord.
Okay. And prays for some time to obtain necessary instruction and to file affidavit in opposition. Stop. The prayer is allowed. List is made after
2 weeks, Lordship.
2 weeks. Stop. Miss. So,
Yeah,
so that
yes.
counts.
3-0, Lordship. For hearing, Lordship.
Okay, yes. What do you want?
Kindly pass over the matter for the day, Lordship.
Okay. Okay. On the prayer of both the land and council for the parties, list this matter. When?
Tomorrow, Lordship.
Tomorrow?
Lordship,
Okay. Pass over, tomorrow,
Lordship. It's a
no,
short
no.
matter,
So
Lordship.
tomorrow probably it will not be possible
In that case, on Monday.
after DV and.
After a week, your lordship.
Matter already, listed. Monday. Monday.
After a week, your lordship.
After a week.
Obliged,
Yeah, please, your lordship.
Yes.
I beg to mention item number 23. Here, notice returned as insufficient address. So kindly allow us to reissue notice to respondent number 3 through proper address, lordship.
Allow you to
Reissue notice to respondent number 3 through proper
let
address.
the matter be called for. Let us see the report.
Okay, lordship.
May it please your lordship.
Yes.
Lordship, I beg to mention hearing item number 31. Lordship, if this matter can come up on September 9th, my senior is indisposed. We are for the respondent.
Okay. You are for respondent.
Respondent.
Okay. You are Miss. Appear on behalf of Mr. Yangavati Land Council for the appellant. Mr.
No, also on behalf of B.N. Sharma.
Some steps. His senior, Mr. B.N. Sharma is indisposed and prays for adjournment of the matter.
If it can be fixed on September 9th,
And
9th of September.
and prays for this matter on September 9th. To which the land council for the appearing on behalf of the petitioner has no objection. Stop, the prayer is allowed. Come on. Please pray for this matter on 9/9.
Bless you.
Yes. Thank you.
For motion, item number 1.
May it please your lordship.
Yes.
Your lordship, by this petition, we are questioning the jurisdiction of the depository court under the rules. Now, the brief facts of the case is our youngest brother, who is respondent number 2 hearing, filed a complaint before the deputy commissioner, claiming a portion of our ancestral common property situated at Gezeke. Now he is not in possession. I'm in possession with our other brothers. Now he lost the complaint, claiming that he is in possession, which is false, and that our deceased father gave him a portion of the land, which also is false. Now, after filing the complaint by respondent number 2, the Deputy Commissioner Kohima endorsed the application to the Depository Court, Kohima. Now, thereafter, the Kohima Depository Court issued summons to me and my brothers. And we refused to participate because the copy of the complaint was not given to us. On what basis he was making the claim, we do not know at that point of time. We also filed RTI asking for a copy of the complaint, but not furnished. And so subsequently, we received the copy of the complaint. The next date for appearing before the Depository Court is fixed on 5th September 2024. Now, in 1984, the rules for administration of justice in Nagaland was amended. And at that stage, the government is making an attempt to separate judiciary from the executive by creating the post of ADC judicial, DC judicial, and assistant DCs having legal qualifications. And accordingly, the rule was amended. Then, although the judicial officers were designated as ADC judicial or DC judicial, they derive their powers from the rules. And in 1999, by an order by notification, the government brought the judicial services under the control of the High Court in 1999. Even thereafter, the judicial officers exercised their powers under the rules until 2013, which your lordship is aware, which is the case of Registrar General versus others. Now, by that decision, by that judgment, the division bench has laid down that despite whatever the backgrounds may be, now the separation of the judiciary from the executive must be enforced, which is found in paragraph 1 of the judgment. The underlying principle is separation of judiciary from the executive, as we find in the judgment. Accordingly, the state of Arunachal Pradesh, the application of the rules in the state of Arunachal Pradesh stands to repeal by implication. The same principle applies to the state of Nagaland, which means the rules stands repealed by implication, as we found in paragraph 13 and 15 of the judgment. Now, after having done away with the rules by that judgment, now in 2013, subsequent to the passing of the judgment, the Law Department of Nagaland issued a notification, which copy of which is next to this petition. Which page? Your lordship will see page 63 of this petition. This is a notification dated 20 December 2013. Page 63, Annexure 12.
Yes,
May I read, lordship?
yes, please.
The government of Nagaland hereby notifies that the provisions for the rules for the administration of justice in Nagaland 1937, which empowers the deputy commissioner and the assistants under Rule 15, are still in force. Therefore, the powers invested by the rules are to be exercised concurrently by the deputy commissioner and his assistants, except in Dimapur, Moza, where separation of judiciary from the executive has been affected. Now, this notification was brought to the notice of the court. And next page, your lordship, 64, in paragraph 3, the government of Nagaland hereby, this is repetition of the same notification. Next paragraph, the said notification prima facie appears to be in violation of the decision of this court in WPC 5783/2006 and other batch of cases. In that view, registry to register a case and notice be directed to be issued to the government, Advocate Nagaland, and the case be posted in the next week. Now, this Rule 15 deals with criminal justice under the rules. It deals with criminal justice. And Rule 23 of the rules deals with civil justice under the rules, 1937. Subsequent to this, the state at page 66 . at page 66, notification dated 28 May 2015. The notification of event number dated 20th December 2013, empowering the Deputy Commissioner and his assistants to exercise concurrent jurisdiction of administering justice under Rule 15 of the Rules for the Administration of Justice in Nagaland 1937 is hereby withdrawn with immediate effect. Now, why it was withdrawn? Because this notification dated 20th December 2013 was in violation of the judgment rendered in Registrar General's case in 2013. Now, though this Rule 15 of the rules relates to criminal justice, there is no difference between whether it is a criminal justice or civil justice under the rules. Therefore, it is clear that the rules for the administration of justice and police in Nagaland, 1937, no longer is in force by virtue of the decision rendered in Registrar General's case.
In the notification 20 December 2013,
Yes.
Rule 23 is not mentioned. 23 is not mentioned in the notification.
Oh, Your Lordship?
Page 63.
Yes. No, it's not
Whether it's a
mentioned.
notification. Rule 23 deals with civil, you said.
Your Lordship?
Rule 23 deals with civil, 15 deals with criminal,
Yes.
23 deals with
Civil justice.
civil justice.
Yes.
But in the notification, this 23 is not mentioned.
Not mentioned. It is
Okay.
only 15
Yes,
because they are aware that the rules have been done away with. But in order to save certain powers for the district administration, the executive, they have put up this notification.
okay.
Now the court finds that this is in violation of the judgment rendered in Registrar General case.
Hmm.
Now, because of this, since the rules has been done away with by virtue of that the decision,
Hmm.
the rules no longer applies.
Hmm.
Now, since the rule no longer applies, the powers of the Deputy Commissioner for endorsing the case to DBs also no longer exist. And the powers for the DBs to try civil suits or cases no longer exist. They have no jurisdiction now. Now, in the judgment in 2013, some discrepancies has come up in the case of Nagaland because the judgment says that in view of 371A of the Constitution, the state of Nagaland can or continue with the functioning of the customary courts. Now the customary courts have been dealt under Chapter 4A of the rules, but Chapter 4A has not been enforced till now. Till now, that has not been enforced, and for all practical purposes, the village courts, the gamburas, the dubashis, they have been treated as civil courts.
Chapter 4A of
the rules.
Okay.
This is a new chapter introduced in 1984 or 87. I think 87. But this is yet to be enforced.
Okay.
This is not enforced. And as such, there is no customary court in Nagaland so far. No designated customary court as such. DB's court is not a customary court. GBs are not customary courts. Village courts are not customary courts. Therefore, in 2022, the government issued a notification, which is next to this petition at page 69. I'm sorry, 67, starting from 67. The relevant portion is at page 68, Rule 4.
Rules 4.
Yes, page 68.
Yes.
4. A,
A.
the process of formation of the village councils will get initiated. No, I'm sorry, not this one. This is in continuation. Is it that? I'm sorry, same page 68, point 5, amendment of section 14. This is Village Councils Act, section 14 of the Village and Area Councils Act. 5, section 14 of the Principal Act, titled Administration of Justice, deleted by Nagaland Village and Area Councils Amendment Act 1985. The Nagaland Act number 6 of 1987 shall be reinserted as under Administration of Justice. 14.1. The village council shall function as village court as envisaged under rules of administration of justice and police in Nagaland 1937 as amended, and administer justice within the village limits in accordance with the customary law and usages as accepted by the canons of justice established in Nagaland and the law in this respect as enforced from time to time. Further, any appeal against a decision of the village court shall lie with the subordinate district customary court and district customary court as decided by the area administrative officer or the deputy commissioner. 2. In case of disputes between / among villages, the deputy commissioner, if the villages fall within the same district, or the commissioner Nagaland, if the villages fall in different districts, may take up the matter for settlement or refer the dispute to the appropriate authority for the settlements. Now, by this notification, which is published in the Nagaland Gazette, the state has created a village court by designating the village councils as village courts. And from this decision of the village courts, appeal would lie to district subordinate customary court. Now, despite of issuing this notification, there is no district subordinate customary court because chapter 4A of the rules have not been enforced. But we are not concerned with the customary courts now. The question is, by virtue of the decision in Registrar General's case, whether the rules in respect of Nagaland still is in effect. It is not, because in paragraph 13 of the decision, the same analogy applies to the state of Nagaland as in the case of Arunachal Pradesh. And in the case of Arunachal Pradesh, by implication, implied implication, the rules stands repealed. And the same analogy applies to the state of Nagaland. If that is so, then the rules cannot be enforced, and in that view of the matter, the Debauches Court have no jurisdiction to entertain a civil suit or a civil case. Also, since the rule has been done away with by virtue of the decision, the deputy commissioner also has no jurisdiction to endorse or make a reference to the Debauches Court. And since there has been some misunderstanding of the decision, now the matter has been referred by His Lordship Chaudhary to a larger bench, and on several occasions the matter has been heard. Now, on the last occasion, the learned Advocate General of Nagaland sought for time, and he submits that in the meantime, the steps to be taken for separation of judiciary from the executive and making provisions whatever is necessary. And that the matter will come up again in October, only in October. But in the meantime, now since the court says that the notification dated 20th December 2013 is in violation of the judgment passed in Registrar General's case. Now, it doesn't make any difference whether it is criminal justice under the rules or civil justice under the rules. If Rule 15 of the rules dealing with criminal justice is in violation of the decision, judgment, then same with civil matters. It no longer is enforceable. We are not preventing the respondent number 2 from filing any case or instituting any case. What we are saying is that it has to be filed in a court having competent jurisdiction, a competent court. The matter was referred to the Deposits Court, which has no jurisdiction. That is our case.
So, according to you, that means as per this judgment, as it also applies, as in the case of the Arunachal.
Yes.
So, the DC doesn't have power to endorse.
No.
What if the petitioner, what if the respondent, complainant filed before the Debasis directly?
They cannot.
They cannot.
They cannot. Because it has to be referred by Deputy Commissioner, Additional Deputy
So that is
Commissioner
as per the
or
rule.
his assistant, yes,
That is as per the rule.
as per the rules.
And what is the prevailing then situations, the circumstances, wherein the Debasis are taking up the cases of the land matters?
Your Lordship, now the question is, since they have no jurisdiction, they cannot take over cases now. The litigant may approach the regular side of the court.
But now so many cases are coming up for the appeal also, in the appeal also,
Yes,
that the Debasis has settled the cases. And it has
yes,
come on appeal.
yes, there are some cases like that.
Yes. What
Now,
about that?
there are some cases where the village courts, the village council, and the Debasis having rendered decisions,
Yes.
now appeal are coming.
Yes.
Now, those appeals were filed before the civil judge senior division or civil judge junior division or district and session judge.
Appeal.
Yes. Now, in that case, in those cases, the issue was that since the civil judge senior division or junior division or district judge, by virtue of the decision in the Registrar General case, since the civil court applies, their view is that they cannot entertain those appeals from decisions rendered by village courts or divorces. Those are some of the issues which have been raised in the reference case, which is a copy of which has been annexed to this petition. That is to be decided. That is yet to be decided. But our view is that since the separation has already been made, because paragraph 1 of the Registrar General case is made it clear. Paragraph 1, Your Lordship, page 31.
Yes.
Page 31, paragraph 1.
Yes.
This order is in continuation of order dated 28/2013 on the issue of separation of judiciary from the executive, wherever such separation has still not been achieved in the jurisdiction of this court, as per the mandate of Article 50 of the Constitution of India, as interpreted by a full bench of this court in Subhasis Chakravarti versus State of Meghalaya. In the said judgment, this court noted that in certain areas in the jurisdiction of this court, administration of justice was entrusted to deputy commissioners, their assistants, and other village functionaries under rules applicable for administration of justice. Whatever be the historical reasons for judicial function not being entrusted to the courts, it was a mandate of the Constitution that administration of justice be entrusted to judicial officers under the control of the High Court in accordance with the provisions of Criminal Procedure Code and Civil Procedure Code. It was observed that doing so was necessary to preserve the rule of law and for protection of liberty of citizens. The rule of law and independence of judiciary are the basic features of the Constitution. So whatever may be the background for application of the rules, what is mandated is that the separation of judiciary from the executive. Then your lordship will see paragraph 13, which deals with the state of Arunachal Pradesh.
Yes.
Page 36, paragraph 13 of the judgment. We now take up the issue in relation to the state of Arunachal Pradesh. The Arunachal Pradesh Judicial Service Rules 2006 have been promulgated by the state of Arunachal Pradesh constituting judicial service. Selection, appointment, and posting of officers has taken place against almost all the sanctioned posts. Courts have been duly constituted and are via central laws extension to Arunachal Pradesh Act 2007, CPC has been made applicable to the state of Arunachal Pradesh. Via notification dated 2010-2011, CRPC has been made applicable to the state of Arunachal Pradesh. Question for consideration is whether Civil Courts Act or the Northeast Frontier Administration of Justice Regulation 1945, the regulations would apply in relation to matters dealt with by the regular courts manned by the members of Arunachal Pradesh Judicial Service, or such courts have to be taken to have been constituted under the Civil Courts Act. Admittedly, the state of Arunachal Pradesh is in no manner different from the district of Dima Hasao and Karbi Anglong in the state of Assam, except that Administration of Justice Act on the pattern of 2009 acts mentioned in para 3 above have not been enacted. Nonetheless, after setting up of courts, it is not possible to hold that the regulations still hold the field even to the extent of conferment of jurisdiction on courts merely because the regulations to that extent have not been expressly repealed. Once Civil Courts Act is held applicable as we have held in respect of tribal districts of Assam, the regulations will cease to operate to that extent. 15. Thus, the administration of justice by regularly constituted courts manned by judicial officers of the cadre will function as per the Civil Courts Act, and to that extent, the Northeast Frontier Administration of Justice Regulation 1945, conferring judicial powers on the executive, will cease to operate. The doctrine of implied repeal applied. Then, paragraph 17. Paragraph 17. We now take up the case of Nagaland. The Nagaland Judicial Service Rules 2006 have been promulgated almost simultaneously with the Arunachal Pradesh Judicial Service Rules, and judicial officers have since been appointed to man the court. The Civil Courts Act has to be held applicable to the state of Nagaland, also on the same analogy. This is the thing. On the same analogy. So if Civil Courts Act applies, then the rule stands repealed. As in the case of Arunachal Pradesh, it stands repealed by implication, although there is no express provision. That same analogy applies to the state of Nagaland. Because now,
In the case of Arunachal Pradesh, subsequently thereafter, some notification has been issued.
yes,
And then also Civil Court Act has also been passed.
yes.
Whether that has been done here in the state.
Your Lordship,
state of Nagaland.
An attempt has been made to bring out the civil court, but then still now it has not been fruitful. But an attempt is made and it is going to be made again.
And then also any notification issued thereafter empowering the judicial officer to take up the cases.
No notification has been issued.
No separate notification.
No separate notification has been issued.
Even after this judgment also.
Yes, but in the case of Nagaland, in the subsequent paragraphs, the courts held that the CPC and CPC is applicable in Nagaland.
So that is there.
That is there.
Where do you
In
find that?
paragraph paragraph 33, 34, 33 says, page 45.
Yes.
We further hold that CPC and CPC are applicable.
This is para
Paragraph 33.
33.
Yes, page 45. We further hold
Yes.
that CPC and CPC are applicable to the regularly constituted civil and criminal courts without in any manner affecting operation of Article 371A or the functioning of village, customary, or other courts other than the regularly constituted civil and criminal courts in the state of Nagaland, manned by the members of judicial service. We made it clear that this order will not affect validity of any orders already passed without following the provisions of CPC or CRPC on understanding that the CPC and CRPC were not applicable to the state of Nagaland. We also made it clear that the state of Nagaland will be at liberty to approach this court for any clarification before the next day. This will also not affect the powers of the state under proviso to section 1(2) of the CRPC and 1(3) of CPC to issue an appropriate clarificatory notification or enacting its own Civil Courts Act. So by this decision, this CPC and CPC is applicable to all regular courts.
So, but no separate notice, as in the case of Arunachal Pradesh, was issued in the state of Nagaland.
No separate notification has been issued.
Oh.
The state has been given the liberty, but it doesn't mean that they will not apply.
So as per this, then CRPC, CPC is applied in the court headed by the judicial officer.
Yes, Your Lordship.
Not by the Dobasi.
Not by the Dubasis.
So this says that without affecting the customary or any other courts. other
Yes.
than the-
But we don't have a customary court, no designated customary courts. Because if you see the rules, the definitions, the powers
So
of the.
in the case of Arunachal Pradesh,
Yes.
say customary court means GB or Keba, whatever name code is called customary court.
Oh.
Whether that kind of what is customary court in the Nagaland? then?
Your Lordship, we don't have a designated customary court under the rules.
What do we
Because-
understand, then what do we understand by the customary court?
Because the constitution of customary courts will come only under chapter 4A of the rules. But That
Chapter
has not
4A.
been put into effect.
Let us see chapter 4A.
Yes, Your Lordship. In the Green Book. Page, in this blue book, Your Lordship will find at page 51.
Page
Page 51,
51.
yes. 4A.
Okay. 4 is
4A,
at page 27.
yes.
4A is 51.
Customary courts, constitution of courts,
Just a minute.
yes. 39.
Yes.
There shall be 3 classes of customary courts as specified below in the state of Nagaland to be constituted by the state government for the trial of suits and cases between the parties, all of whom belong to a scheduled tribe or tribes with powers and jurisdiction mentioned in this chapter. Village courts, subordinate district customary courts, district customary courts. Now, village courts. Village courts, then this is the lowest court, trial court, then subordinate district customary courts at page 53.
Yes.
There shall be a subordinate district customary court at places to be notified by the state government. Each district customary court shall consist of officers having judicial appearance. This may be not so relevant, Your Lordship. But the next one is subordinate district customary courts. First one is village courts. Third one is district customary courts at page 54. And in this district customary courts, it says, there shall be 1 district customary court for each district. Each district customary court shall consist of 1 presiding officer and 2 other members to be selected for any particular case by the said presiding officer for the panel of names and members appointed by the state government and included in the list, prepared, maintained, and duly notified for each district customary court. Then appellate provision, Your Lordship. '58, Your Lordship. District customary courts. Rule 55. The district customary court shall be the court of appeals as against the decision of the subordinate district customary courts and village courts in suits and cases, both civil and criminal, decided by the state courts. So the thing is, this 4A has not been introduced and no courts have been constituted under this. So there is no such customary court.
So this is to be notified to enforce.
This is to be enforced, but this has not been enforced. That is creating the problems, Your Lordship.
Why it is not enforced, not being enforced?
Your Lordship, we don't know, we don't understand the wisdom of the state government. But as per the submissions of the learned AG, Nagaland, in the last occasion, when the reference matter was taken up, he submitted that steps will be taken for separation of the judiciary from the executive and for creation of these courts.
So this 4A customary court, when this was proposed?
This was 19. 1987, I believe. 87, no?
Since 87, it has not yet been enforced.
Not enforced.
And then no civil code act has also been passed,
Not yet passed.
not passed.
Not passed.
Then how the several existing courts, village, Dobasis and all those, how it will, who has a power and who has a appellate power, how would we know that?
Your Lordship, under the rules, under the old rules.
Hmm.
Now decisions from the village councils, gamburas, or dubasis, appeal is available under Rule 31 of the rules.
Okay, that is. Okay.
And there will be,
Rule that is not covered under this judgment
no,
that survives. That means.
no, because the rules have been done away with. There is no point covering all this. The only saving clause given in the decision is by virtue of 371A.
Hmm.
The state has been given the liberty to create customary courts. Although that was not expressly made. That is what they say, 371A. There's a saving provision for the state of Nagaland to have customary courts. Otherwise, DBs are not customary courts.
Now, this case then is connected with this, the case pending before the.
Yes, the
DB.
question is involved in that.
Hmm.
Yes.
Then whether this court, a single bench, can decide.
Your Lordship, subsequently, this may be referred to, this may be clubbed with that one. Subsequently.
Hmm.
But for the time being, notice may be issued to the respondent. And then the summons issued to me to appear before it may be suspended. And further proceeding of the Dubois court may be suspended. Subsequently, this will club with the other case,
Yes.
cases.
It has to be.
Subsequently, yes. But for the time being,
Because according to you, it has been issued in violation of that
yes,
judgment.
that decision,
Hmm.
judgment.
So then what we'll do is that we'll take up this on the next date is fixed on 5th
October,
September.
before Dubois court.
Yes,
Yes, on the 5th September.
on
up
5th
to-
September.
Yes,
So what we'll do is we will pass any interim order on 3rd, 1 day ahead, and thereafter we'll just explore also and then refer it if required. Then on that day, we'll take up with the interim also, prayer also, on 3rd, because it is fixed on 5th only.
on 3rd September.
Yes. Prior to the date fixed. See, yes, state.
Yes,
So this is their submission.
yes, my lord,
What do you have to say?
No. my lord. Two review petitions are being handled by the. What should we come to this, similar to this? What should we come to page 54
54 of,
of our petition? Now this, the first petition is Civil Revision 5 of 2020. Here, Lordship,
the same party.
Lordship, I'd like to highlight some of the points so that your Lordship would be able to comprehend the metrics of the case.
Yeah.
Why it is like that. It is very clear that we don't have a Civil Courts Act in Nagaland. It is proposed, committee has been formed, and the act has not been come out, but it is awaited. And so far as what my learned senior friend has said, chapter 4A, Constitution of the Customary Court,
Hmm.
as envisaged in the 1937 rules. This has also not been done. but it is also under active consideration by the state, so as to implement. So now it's a question of jurisdiction, what my learned senior friend is saying. Now, in the same case, where my learned senior friend is a counsel for the revisionist, now, Lordship may kindly see in Civil Revision 5/2020 was filed, revision was filed by the petitioner against an order passed by the Village Council Kohima under Dimapur district. Kohima Village Council has passed an order, Village Council order, and appeal was come to the civil court. That means District Incision Court, District Court of Dimapur. District Court has rejected the appeal, saying that it has no jurisdiction as per the 37 rules, 1937 rules. So that way it happened. Now, number 2, Civil Revision 6 of 2021. Civil Revision number 6 of 2021 is represented by my learned senior friend. Lordship, may kindly come to page 55.
55.
Page 55.
This is
the link with Civil Revision 6, 2021. Kekrisili Negi.
Okay.
Yes, in this case, a judgment was passed by the Jotsoma Village Council under Kohima district. So the petitioner went to the court of the civil judge senior division in Kohima. That also rejected, saying that civil courts has no jurisdiction under the rules. That means 1937 rules, because 1937 rules speaks about DC in its assistance only. It does not speak about district assistant judge, civil judge senior division, civil judge junior division. In absence of that, in the rules, it was rejected. So revision has come before these things. Now, Lordship, may kindly see page 56, the last order.
Yes.
Of the division bench. Heard Mr. Limoa, learned counsel for the petitioner in criminal revision 5 of 2020, and Mr. R. Erelo, learned senior counsel for assessed by Mr. L. Erelo, learned counsel for the petitioner, and civil revision 6, 2021. Also heard Mr. K. N. Balkobal, learned advocate general, assisted by Mrs. Nitya Nampire and Mr. Moa Emchen, learned senior government advocate for the state respondents. The issue under reference is as to whether the statutory civil courts in the state of Nagaland has been empowered to adjudicate the case and a decision rendered by the village council. TB's court, Mr. Balkobal, learned advocate general Nagaland, submits that the state government is seized of the matter and is in the process of coming up with a suitable solution to address the issue raised in the present petition, and therefore seeks for some time. In view of the submissions made by the learned advocate general Nagaland, this case on 16/10/2024, that is 16th August, 16th October, I'm sorry, your lordship. It is expected that under that facts, the learned advocate general shall make instructions available before this court. Now, lordship, both this present revision petition and the two are very similar. And in this two, learned additional advocate general is appearing, and I'm assisting the learned advocate general because it is a matter of great concern for the state. So now, since learned advocate general is coming on 16, let this, if my learned senior friend agrees, let this matter be linked up with the two revision petitions.
So these two revision petition is before the.
Because it is very similar. One is a summon, our present revision is a summon issued by the Tabashis court. My learned senior friend is trying to state that, saying that it is the summon is out of jurisdiction. The stand of my learned senior friend is the summon issued by the Debashis court to him is out of jurisdiction. But your lordship, if you kindly see the rule 23A of the 1937 rules. Rule in this law book, you'll find your lordship in page 28.
Page 28.
In my book, it is written, it is seen in page 28. Rule 23A.
23A, yes.
Now let me read that. Your lordship, page 27, civil justice, 23.
23.
Rule 23.
Okay.
Rule 23. The administration of civil justice in the state of Nagaland is entrusted to the Deputy Commissioner, Additional Deputy Commissioner, Assistant to the Deputy Commissioner, customary court, constituted under Chapter 4A of the rules. Chapter 4A.
Noted.
Chapter 4A has not been given effect to. It has not been notified.
Yes, yes, yes.
So as of today, your lordship.
Yes.
Tapashis. Fourth category comes tapashis. And other village authority may be appointed by the state government from time to time by notification in the official gazette. Provided that the government of Nagaland shall be empowered to invest any officer of the state government having judicial experience with the powers of the Deputy Commissioner for the trial of any particular civil case or cases, and the officer so invested with the powers of the Deputy Commissioner shall be designated as Deputy Commissioner Judicial and shall exercise all the powers of the Deputy Commissioner in the behalf. Now, 23A, your lordship. Next page, 23A.
Yes.
This is important in our case.
Hmm.
The Tabashis. Now, the summon has been issued by the Tabashis. The Tabashis henceforth shall try and decide such civil cases only as may be referred to them by the Deputy Commissioner or Additional Deputy Commissioner or Assistant to the Deputy Commissioner as the case may be. This is there is no interpretation here. The statute is very clear. Now, for the Tabashis, they have to decide whatever has been entrusted to them by the Deputy Commissioner. To my reading of the petition, your lordship, to my reading of the petition, lordship, you will find, to my reading of the petition, your lordship, you will find lordship, may kindly see page 50
Of the?
of the revision of the present petition, page 50. This is the typed copy. Page 49 is the copy, and this is a typed copy, is very clear. Now, the complainant, your lordship, in this civil letter, has written this to the Deputy Commissioner, Kohima, Nagaland, prayer to settle a dispute between me and Sevini Keseze over my private property. That Sevini Keseze is the petitioner here now, your lordship. With reference to the above mentioned subject, I beg to bring this representation for your kind consideration and necessary action. That's sir. I am in possession of a plot of land and building situated at Pezelitse Colony, Kohima, Nagaland, which is an ancestral land of my father. I have been staying in the said land from the year 1993, and until then, there was no disturbance from any quarters. However, in the month of March 2024, Mr. Sevini Keze, that is the petitioner here, started disturbing my peaceful occupation over the said land and building on the ground that the land and the building belongs to him. It is stated that the aforesaid land has been given to me by my father, late Kutosevi Keze, and I have constructed one RCC building and 4 assembly building over the said land in the year 1993. As stated earlier, earlier, in the month of March 2024, Sevine Kezeze and party came and damaged 4 Asomtype building and threatened me and my family with dire consequences. In view of the above, I request your kind authority to look into the matter and refer the matter to your Tabashi's court for the ends of justice. Your Lordship, this letter is written by the private respondent to the Deputy Commissioner. Now, your Lordship, of course, the endorsement leader is not there. The endorsement by the Deputy Commissioner is not there, but here, your Lordship, you can see page 49. It was processed. It was processed from Deputy Commissioner to the Steel Satar, and then Steel Satar to the EAC, extra Assistant Commissioner, Judicial, and Judicial Section that way.
So this
So
was
by implication, we can understand that this complaint letter written by the private respondent on 22/5/2024 was been endorsed. Because complaint was not written to the Tabashi's court, it was written to the Deputy Commissioner. And consonance with the chapter 23A of the 1937 rules.
So the Deputy Commissioner endorsed it to the Debasis for settlement.
By implication, we can understand that. I can
There is no
understand that.
question of implication. When there is question of law, it appears that this was sent to ADC for necessary action. ADC sent it to SDO Sadar, and SDO Sadar said put up. Then it has gone to EAC Judicial. Now, whether EAC Judicial have been designated as Assistant to Deputy Commissioner, unless he is designated as Assistant to Deputy Commissioner, he also has no jurisdiction whatsoever to endorse the matter to the Debasis Court or a reference. And so this is not a reference, in fact.
So we do not know
Your Lordship.
how this came to the Devasi. You mean to say? How this came?
How this
How
came
this
out-
case,
this- we cannot say this reference to the Debasis Court by Deputy Commissioner.
But then as per this 23A,
Yeah, references to be
Debasis,
made
Debasis,
by DC or
Hmm.
his assistant.
if it is referred by the Deputy Commissioner or
Yes.
additional Deputy Commissioner or assistant to the Deputy Commissioner, as the
Yes.
case may be. So the Debasis can take up the case.
If the rule is enforced, they can. But now this rule no longer exists.
This rule itself.
Yes, the whole rule has been done away with by the disband decision in Register General case.
So this is what he was submitting, that this rule by the judgment 2013.
My learned senior friend is saying, but to my reading of the Registrar General case, I do not find anything which says that the rule 37 rule no more exists in the state. It is still following your lordship. It's still following.
No, that is what he's
State
saying.
Assembly has not notified
Should
that,
not have
notified that.
been followed, but why it is following? It should not have been followed.
Lordship,
Your submission is that it should not have been followed after the judgment. Is it your
Registrar
submission?
General judgment is 2013.
Your Lordship, because of the ignorance at some point of time, maybe some parties have proceeded under the rules. But subsequently now, it has come to light that this cannot be enforced, because if this is not enforced, then this will be strictly against the judgment.
Judgment.
Yes,
So as per the judgment, this should not have been followed any longer.
no more. This is done away with.
done away with. But then in the state of Nagaland, it is still following. DCs are endorsing, referring the case to the Dabasis, and Dabasis are also deciding the case.
Your Lordship, in other cases, no, but this is one of the instance which has now caught my attention. And for this, since the rule is no longer in force, now we are approaching this court for that.
So,
Because you see, Your Lordship, now as per the decision rendered in the Registrar General case, if we are to interpret interpret in such a way that this will be enforced, then there will be 3 types of courts in Nagaland.
there will be
3 tiers of court. One is civil courts, all the civil court, regular courts, applying CPC, CRPC, and Civil Court Act. Second one is the executive governed by the rules. The third one is customary courts. Will that not be inconsistent with the functions of regular courts? We cannot have that 3 types of courts.
in the state of Arunachal Pradesh, after the judgment or prior to the judgment also, and then after the Civil Court Act, Arunachal Pradesh has 3 tiers, 4 tiers.
Yes.
The district judge, district and session judge or district judge in the top, then chief
Yes.
judicial magistrate or
No.
the civil judge senior division,
Yes.
judicial magistrate first class or the judicial civil
Correct.
judge junior division,
Correct.
and in the last it will be a customary court by
Definitely.
whatever name called.
Yes. Nagaland,
Four.
No,
That-
Your Lordship, that is correct.
That is
that is all right. Nagaland also,
What I'm saying is that now,
Hmm.
if rules applies
Hmm.
as of today,
Hmm.
what will happen? Now, one set of court, which is meant by the judicial officers, would be governed by the Civil Court Act, applying the letters of CPC and CRPC. They cannot entertain anything under these rules. Second one is, if these rules applies, then this rules is the executive. The executive will function under these rules, applying the spirit of CPC and CRPC. The other one is the village court to be constituted under Chapter 4A, which has nothing to do with the rules or the Civil Courts Act or CPC or CRPC. That will be inconsistent with the separation of the principles of separation of judiciary from the executive. And how in one state courts functions one way by applying the letters of CPC, CRPC, one by applying the spirit of CRPC, CPC, and one
without
by customary court.
customary court.
That will be inconsistent with the
Right.
Civil Courts Act.
Right.
That is not permissible.
Lordship,
Means
what
I
my
have to
learned
choose. The party is given the liberty to approach this court or that court. Then how can we expect justice? Now the principle, the underlying principle of the division bench decision in the case of registrar is that the separation of judiciary from the executive. That is the underlying principle.
It has to be.
It has to be. And so in that view of the matter, the state of Arunachal has been settled. And similarly, same with Arunachal, as the court says.
And within the customary court, there can be appeal.
It is there, provision is there in the
Uh,
chapter 4A. district customary court, subordinate district customary court, village customary court. Hierarchy is there. Hierarchy is there. But
Within the
the
village.
only thing is that,
Within the customary.
the only
court,
thing is that
only.
it has not
Yes.
been given effect to. That is why
It
the
has to be-
confusion.
It has to be actually, why
Uh,
to create confusion?
That is why advocate general is saying on the hearing dated for 14/8/2024, as I read
It
it
has
out.
to be settled.
He's going to come up with a comprehensive instruction to that effect. That is one. I agree with the submission of my learned senior friend saying that the 37 rows regarding the judicial officers. Now, judicial officers are given the name of district and session judge, touring criminal, like that, till the last, that is, magistrate fracas in civil judge junior division. This hierarchy is there. And then Nagaland Judicial Service Rules 2006 is there. Now, all the judicial officers under direct control of this Honorable High Court. So that is there. That is there. The only predicament, the only handicapness is that judicial officer by their name and designation are not inserted in the 37 rule. 37 rules, it's a, as your lordship is well aware, it's a pre-colonial law, 1937, and which is still existing with some amendment. The only thing is that it has not been, their name has not been giving effect to here. It is also under active consideration by the state. Instead of deputy commissioner and his assistants, why not district and session judge?
Yes.
Yeah.
After this,
That is like that.
there is a notification in Arunachal, in case of Arunachal Pradesh, then the DC, EAC, ADC doesn't have any power, judicial power now. Except in the case where there is no judicial officer being posted, they used to take, where there is no judicial officer, they can take up being, of course, endorsed by the judicial officer going on leave or the remand. They can remand, and of course, in urgency case, bail, in absence of the judicial officer on leave, because now judicial officer, less judicial officer.
Yes.
Except for that, they cannot take up, they cannot even endorse. If the deputy commissioner start endorsing any case to the Dabasi, or we don't have a Dabasi, we have a customary court like Sekebang. So if the deputy commissioner or ADC endorse the case for settlement before the customary court, then he doesn't have a power to endorse.
Yes.
He doesn't have. It has now, after the Civil Court Act, the complainant can file straight away directly to the court of the customary court, not to the DC-ADC. DC-ADC doesn't have a power to endorse.
That is why, your lordship, that
No, your lordship, the spirit of separation.
Hmm.
Now, what is the principle of
Yes.
separation?
Yes.
Once it is separated,
Hmm.
then the executive have no jurisdiction to
No jurisdiction.
entertain any disputes.
So what?
lordship
this
notice
case-
be issued. Notice be issued.
Will issue notice. So let us see the records also on third. On third, we'll pass necessary order.
Your lordship, in the meantime, further proceeding may be
No, on
suspended.
third only, because on fifth only, it will, the next day is fixed on fifth only. On third, we'll pass necessary order for that. Okay. For the time being, we'll issue notice, okay. Mr. Aguirre, Nane, senior advocate. The senior counsel for, assisted by Ms. Land counsel for the petitioner. Also had Mr. Mohan, Land senior government advocate
That is
for the state of Nagaland staff.
Lordship, only two respondents, Commissioner Secretary, Law and Justice, and the private respondent.
Yeah. Yes. Correct. Issue notice. No, just a minute. This is a petition under Article 227 of the Constitution of India, read with Section 24 of the Civil Code, Civil Procedure Code 1908, praying for setting aside a proceeding in all the case number 4, 2024, pending before the buses wooden wicket DB's bracket close, Kohima. On the ground that the said court doesn't have the jurisdiction to try the case and or an alternative and or to transfer the matter to an appropriate civil court of appropriate jurisdiction. Stop. Issue notice returnable by 3rd. Returnable on 3rd September. On which, okay, 3rd September, stop. Since Mr. Moaim Chen appear on behalf of the respondent number 1, no formal notice need be issued to the said respondent. Stop. You need extra copy? That's enough, I think.
No.
Okay. The petitioner shall take steps upon the respondent number 2. Dusty?
Your Worship, yes.
By way of Dusty service. Within 2 days from, within 2 days from today, Stop. The interim prayer shall be considered on the next day, that is on 3rd, 3/9/2027. List is matter on 3rd. Okay.
Your Worship, oblige, Your Worship. For motion, item number 2.
Just a minute. Whether record needs to be called for? Whether records need to be called for?
I do not think so.
Not required.
Not,
There is no record.
I don't know what record.
If the complaint was filed before the deputy commissioner, probably there is a record.
There must be a record.
Okay, call for record also. Call for the record also. Let us see.
Yes.
Lordship report is not necessary.
Not necessary.
No.
Okay, leave it then.
Okay.
May please, my lord.
Yes.
My lord, this contempt petition has been filed for non-compliance of order dated 29 February 2024, Lordship. This matter relates to appointment on land ownership basis, Lordship. The petitioner approaches Honorable Court for appointment on land ownership basis for donation of land free of cost to build a piggery farm in Tuensang under the establishment of animal husbandry and veterinary services, Lordship. While Lordship, now while this Honorable Court was considering the case of the petitioner, the case was disposed of by giving direction to the state respondents.
What is the specific direction?
The specific direction is that, Lordship, since the matter relates to land ownership basis on an oral agreement, the single judge felt it necessary that the deputy commissioner should make a verification on whether there exists an oral agreement and whether the petitioner is a genuine land owner, Lordship. So accordingly, verification was done by the deputy commissioner and recommendation was sent to the respondents, to the department, Lordship. Because, Lordship, the specific direction of this Honorable Court was that on the recommendation of the deputy commissioner, the state respondent number in the writ petition, respondent number 2 and 3 shall make the appointment on the basis of the recommendation.
Let us see the
Yes, Lordship.
operative portion.
Operative portion, Lordship, page 16, paragraph
Yes.
11, Lordship.
Yes,
If I may read the
please.
second paragraph, Lordship. Maybe, Lordship, I'll just read the entire paragraph 11, Lordship.
Okay.
Taking into account that there is a dispute as to whether the petitioner's family has donated the land free of cost without any conditions or there was an oral agreement. It is the opinion of this court that such verification can only be conducted by the Deputy Commissioner of the concerned district in terms with clause 3B, which has been quoted herein above. Under such circumstances, this court grants the liberty to the petitioner to submit all the documents along with statements of the witnesses before the Deputy Commissioner Duen Sang within 30 days from the date of the instant order. The Deputy Commissioner Duen Sang shall be at liberty to take the statement of those witnesses of the government officials of the concerned department and the district administration in respect to the time when the land was donated, and thereupon shall make necessary recommendations, Lordship. On the basis of the said recommendation, the respondent authorities, more particularly the respondent number 1, 2, and 3, shall take appropriate steps for filling up the vacancy. Taking into account the above observation and direction, this court sets aside the approval letter dated 6/03/2023 insofar as the respondent number 4 is concerned. Lordship, now
So now they have taken steps.
yes, the Deputy Commissioner has taken steps. He has done his verification by calling witnesses, even the petitioner, and then accordingly verification was done and recommendation was sent. Recommendation was sent on 7th of June 2024. Lordship, if I may take you to the recommendation. First, the verification report and then the recommendation. Page 19 is the verification report, Lordship.
Okay,
19, Lordship, if I may read the second paragraph of this.
okay.
In this connection, the village council and the landowners petitioner has stated that a veteriner's office and piggery farm was established in the year 1972 with an oral agreement to provide grade 4 posts to the landowners. Upon verification of the documents and the statement made by the chief veterinary officer Duen Sang and village council P. Kel Duen Sang village, it was ascertained that the petitioner, Mr. C. Sikam Jang, is one of the landowners of the Sidam Piggery Farm at Bilashi Kel Duen Sang village, and neither his grandfathers or children have availed any grade 4 posts so far. The village council and the landowners expressed their resentment on the matter and warned on taking back the land in case the department fails to accommodate the appoint Mr. C. Sikam Jang to the vacant post. Therefore, it is felt necessary that the matter may be recommended considering the genuineness of the case. Hence, the matter is submitted to you for your information and necessary action. Now, the additional Deputy Commissioner Duen Sang at page 18, Lordship. Page
This
18.
was done on 17/5.
Yes,
Okay.
2024. And then the recommendation was made by the Office of the Deputy Commissioner to the Director, Department of Animal Husbandry and Veterinary Services on 7/6/24. But till now, Lordship, the recommendation has not been acted upon because, Lordship,
Have you made representation thereafter?
Lordship,
Because there is no specific direction that should be complied within such.
yes,
period.
my Lordship.
No
So,
period.
yes, that's why, Lordship, we have,
Have you made any application or representation?
no, in fact, the department called the petitioner.
Hmm.
Petitioner
Hmm.
and their family, Lordship. And then it was informed that on the first occasion, this case were under active consideration. They are processing it, and to wait for 1 or 2 weeks, Lordship. But then,
No,
again, on the second occasion,
How the contempt made out, then there is no time time has not been specified.
but Lordship, the specific direction of this honorable court was
Now you
to
say
act
that
upon.
complied, it was complied and forwarded. Now the DC has forwarded to the director and director is under consideration, it says.
Yes,
Have you-
Lordship. Lordship, if I may, Lordship.
Yes, please.
That direction was to the director and the commissioner and secretary and the chief secretary, not to the deputy commissioner. The verification was to be, since the matter pertains to whether there exists an oral agreement or whether the petitioner is a genuine landowner, Lordship, and as per clause 3B, only the deputy commissioner can make the verification. Because at ground level, that he has to call witnesses and ascertain whether there exists an oral agreement and whether the petitioner is a genuine landowner. So because of that, liberty was granted to the petitioner to submit our documents to the deputy commissioner.
Hmm.
And as well as the department, the respondent number 2 and 3 in the writ petition has send the case to the deputy commissioner.
Yeah.
Lordship, what I'm trying to assert here is that, Lordship, the direction was not to the deputy commissioner, but the deputy commissioner is the right person to do the verification. And accordingly, this writ court has directed the respondents to make necessary appointment as per on the basis of clause 3B and on the recommendation made by the deputy commissioner. Deputy commissioner has done his verification, Lordship, no doubt, Lordship. But the compliance has to come from respondent number 2 and 3, and here in respondent number 1 and 2.
Are they saying that no, they are not appointing?
Verbally, they have intimated. That's why I'm coming before this honorable court. Verbally, when we were called to the office, verbally they have, on the second occasion, they have said that
How
now.
do we believe the verbal? You could have made an application, representation
Lordship, since
to consider, since the deputy commissioner has submitted.
Lordship, since it is a contempt jurisdiction, Lordship, I felt that it is not necessary for us to, since the decision, the direction of this honorable court is unambiguous and clear, Lordship, and it is in the knowledge of the, is in the knowledge.
Complied by when?
No, there's,
Complied by?
because the problem is that there's no specific time.
That is why I'm saying.
Yes, Lordship.
That is why I'm saying. You could have asked, you could have make an application or representation asking them whether they are compliant. And for compliance, wait for reply. And if they refuse, then of course contempt make out.
But Lordship, the judgment was passed on 29th of February.
So
we have sent it, we have, and the decision of this
was forwarded on June only, June 24th.
Yes, recommendation was,
24th, okay.
yes, recommendation was sent by the deputy
Yes.
commissioner only in the month of June, Lordship.
And they must have received by June only probably.
Yes.
Then July, of course. Then you see, thereafter you see, it is duty on your part to get information whether they are complying or not.
Yes, we have, Lordship, we have.
Where?
We have, in fact, Lordship, we did. Lordship, we admit we did not have
Because there
sent
is
any
specific time.
representation.
Unless there is a specific time and unless they say they refuse to comply with, then how the contempt will make, how it will be a contempt case? Unless they refuse. They have not yet refused.
Lordship, but they have been sitting ducks on the recommendation by the deputy commissioner. And then
Now you see.
sufficient time has
it's a
left.
Government department, it takes time. So if they have received on time and they are sitting over and then not making any any appointment, if they say, if they refuse on paper, black and white,
Lordship,
then the contempt will make up.
Lordship, on my part, Lordship,
Yes.
on my part, Lordship,
So that is your part you have not done.
Lordship, verbally, they have intimated.
No. Why do we believe verbal? How? If they comes and they never they never came, then
Lordship, at this stage,
we are considering their case, then it's not easy. We are considering the case, why they should go? If they said they never came before us, we are considering the case. It is under active consideration then.
no, Lordship,
Then?
recommendation has been done.
A small step asking them, this was there and it was submitted on June 24th, not yet complied, kindly comply, appoint. And then they will reply, even if they don't reply also,
So
kindly
in
reply.
the, so far as I've understood my Lord's query, Lordship, in the event, we send a representation reminding them to comply with the direction of this court. If they do not reply, or if they do not make any
Then
action.
you see, you are advocate, you know how to ask them, giving some time. Within that hour, which will approach, and then the course of action.
Lordship, eventually we have to
Will
come to
arrange.
this honorable court again,
Now-
Lordship.
Now you see how, now you tell me, what is this contempt? How the contempt, what is the ingredient?
Lordship, the specific direction.
There is a direction, but there
Yes.
is no time specified. And then it is, see, not, you see, it was forwarded on June only, June from the deputy commissioner. It will take time to reach their official, no? So it is assumed and presumed that it is under consideration because deputy commissioner has done as per the direction. So I think, how do we issue notice also here under such case? No
Lordship,
case made out for issuance of notice also.
Lordship, at this stage, notice may be issued, and
No, how?
in the meantime,
No, no,
I'll
no.
take.
So on what basis? On what basis? How the contempt made out?
So on the basis of Lordship, on the recommendation of the Deputy Commissioner, Lordship,
Now let us see the contempt. What do you understand? The contempt. It is still under active consideration. It is assumed. Recently only it was forwarded and no time is specified. Then
yes, that is the Lordship in
yeah,
the.
that is why I'm saying, in order to get her,
Yes,
to make out your case,
yes.
ask them to comply within so and so. It's been long. And then unless you, if fail to comply within 30 days, we are bound to approach.
But if.
Make out that case.
Yes, if my lord feels that, then I will do accordingly, Lordship.
It's not, it's your case.
No, Lordship,
Ah.
contempt
No,
jurisdiction
no,
is.
what I-
the-
this is my,
the court, Lordship.
this is what I felt.
Yes, Lordship.
It was required,
Yes, Lordship.
but you have not done that also.
See, Lordship, as far as I'm concerned, Lordship,
Hmm.
contempt jurisdiction lies with the High Court, with the court. And
Yes.
then, we as petitioners, we do not have anything to say on that one, except to inform the court that whatever direction has been passed has not been complied so far.
You make a representation, better. Make a representation.
I can
and
do that,
then
Lordship.
come.
I can do that.
Better
Lordship.
withdraw this and come again.
Lordship, I can do that.
Okay.
But Lordship, only the problem, my apprehension is that since like my lord has mentioned, there is no specific direction given in the.
That's why I'm saying.
Yes, Lordship.
Now, since the court has not given,
Yes,
so now you have to give
yes, Lordship.
sufficient time to them.
Okay, Lordship.
And then they'll answer.
Understood, Lordship.
If they are not, if that doesn't indicate
Yes, Lordship.
or not willing to comply with the case, yes, then it will make out.
All right, Lordship, I will do
But
accordingly.
let them reply
Yes,
their willingness, and then they'll ask for time,
yes, Lordship.
where it will take some more time.
Lordship.
Hmm? Okay. Mr. Okay, Tosio Long Kumar, not counsel for a petitioner. At this stage, wants to withdraw this contempt petition with liberty to file afresh, if so advised, no? The prayer is allowed with liberty as prayed for. No? Okay, this contempt case is closed, with liberty is prayed for. Okay,
Obliged,
it's
Lordship.
better.
Obliged, Lordship.
Yes.
For admission, item number 5.
Yes. Yes.
Last occasion, your lordship, I was directed to place instructions in regard to the action
Hmm?
and regard to the steps taken by the
Yes.
by the committee for considered by the authority of the state for consideration of the remuneration and service matters of the fixed fee and contingency employee. The petitioners happen to be contingency employees, and they were directed to give scale up pay. They were contingency employee. We did not appeal. We did not make any appeal for that. Now, the committee has been constituted, but they have 2 sittings. Committee has already 2 sittings has been made, and till today, the steps taken by the committee has not been placed before me by the committee. Now I'm communicating with them, so your lordship, another 3 weeks will be granted to me, so that I'll place the recommendation of the committee before your lordship, or the steps taken by the committee in regard to the pay, remuneration, and salary of the contingency and fixed fee employees.
They have started taking steps.
They had started taking 2 sittings has already been made. I was informed. So I will allow 3 weeks time, your lordship. Because state government says of the matter, and it's very serious. We are very serious about it.
Mr. S. One, sorry, Supam.
Lordship, if I may be, Your Lordship.
Yes,
On the last occasion, that is on 6/8/2024. This
Yes.
Honorable Court order, Your Lordship. On the last paragraph, the order, Your Lordship. The three respondents were directed to
within 45 days.
the last paragraph, Your Lordship.
Hmm.
Considering the submission of the learned counsel for both sides, I have also perused the case record. Accordingly, the respondents' government authorities are hereby directed to place the recommendation from the committee concerned and to take all the instruction and place it before this court strictly on before the till next date of listing, Your Lordship. Since they have not
You have
placed, Your
not
Lordship,
received. So these you have not received.
yes, Lordship. So I pray that since they are seeking for 3 weeks' time, Your Lordship. Last occasion. So on the next list, that Your Lordship, direction may be given to comply this court order strictly, Your Honor.
Okay. Mr. S. Mr. Promoter Walling, Land Council for the petitioner. Start. Also had Mr. Moyamchen, Land Senior. You are
And for respondent 3 and 4.
3 and 4. Moyamchen, Land Senior Government Advocate, representing respondent number. You are for respondent number?
Financial Commissioner, Your Lordship.
Hmm?
Additional Chief Secretary and Financial Commissioner,
Yes.
respondent number 1.
Oh,
One and
one.
two, Your Lord.
Okay, respondent.
One.
One.
One
And Miss,
1 and 2.
and Miss, you,
Ali Dosi.
for respondent number 3 and 4.
3 and 4.
Okay, start.
3 and 4. 3 and 4.
Mr. Moyamchen, Land Senior Government Advocate, for the respondent number 1. Submits that although the committee constituted to consider the case of the petitioner as said twice. No. So this is to be compliance of the order 6/8. You want this? Okay.
Yes, Lord.
Mr. Moyamchen, Government Advocate, for the respondent number 1, pray for further 3 weeks' time to comply with the order of order passed by this court on 6/8/2024. To place the recommendation.
Instruction from the committee.
To place this instruction.
Yes, Lordship. Since the former
instruct-
committee, Your Lordship.
Okay. To obtain instruction from the committee. And to place it before this court. Stop. The prayer is allowed. This is matter after 2 weeks, on which date the Land Senior Government Advocate for the shall okay, after 3 weeks, we'll say 3 weeks. Okay. So on next date, you just place it.
Lordship.
It was clearly directed
Correct, Your
to
Lord.
place the recommendation from the
Correct.
committee concerned and to take all the instruction.
Correct.
And then since you said that the committee has already said twice, and then I think probably they must have come into some definite decision.
Correct.
And some order might have also
Yes,
been
yes.
passed. So obtain the necessary instruction, the latest status of the committee's decision
Sure.
and the committee's decision and how they are going to proceed with. Yeah. Okay.
Obviously.
Obviously.
For admission, item number 6.
May I have Lordship?
Yes.
Lordship, I received the affidavit of the respondent 2 this morning. this morning only.
Affidavit.
Affidavit in opposition
Okay.
of the respondent to have received.
Hmm.
So, Lordship, I may request some time to go through and if need be, I may be allowed to make a reply.
Okay.
But Lordship, before Lordship, I may be allowed to address this court on behalf of my client, the petitioner.
Hmm.
But Lordship, the petitioner has been receiving calls
Hmm?
from the IO, the investigating officer,
Receiving?
phone calls.
Okay.
And since my client, she's still undergoing medical treatment, Lordship may be gracious enough to revisit the order dated 21/9/2023, Lordship. Lordship may kindly come to order dated 21/9/2023.
Yes.
21/2023, Lordship, at page number 2. Lordship, I may be allowed to read, Lordship.
Yeah.
Having considered the submissions made by the learned counsels for the parties and the documents annexed to the petition, which shows that the petitioner is a lady about 63 years of age, having serious ailments for which she had undergone surgery. In the interim, the petitioner is allowed to appear before the investigation officer as well as the learned CGM Dimapur through DC on 29/2/2023. On the date we have appeared, but Lordship, for the interim in respect of the investigating officer, if any investigation is made, if the IO
She is
can.
not appearing because of her age.
No,
She
she
is
has
not
appeared.
appearing.
She has appeared.
She has appeared.
She has appeared.
Statement
Now,
recorded.
yes, it has been recorded. But now,
151 recorded.
yes, but now what is coming to light is that the IO
Huh.
is trying to harass the petitioner, my client, Lordship. So, Lordship,
That can't.
if
The state, who represent the state? If you're objecting,
see, there are private parties, Lordship. One is the global university, and one is the complainant, Lordship. Now the harassment is being carried out by the investigating officer.
okay.
So,
Mr. Pusegapati,
if Lordship may at least direct the
Land Council for the.
IO not to harass
case for the state,
my
yeah.
client, Lordship.
Pusegapati, Land Council for the petitioner. Also had Mr. You are for?
Respond to number 2. Sushil Singh.
I will respond to number 3.
Okay.
We're yet to file counter affidavit. Lordship may kindly grant 3 weeks time.
Okay.
I have filed my counter.
So, earlier there was a direction allowing the petitioner to appear before the IO of the case through VC.
That's right.
And she physically or
Lords.
via VC.
By
VC appeared, her statement recorded, but repeatedly probably it appears that the police is causing harassment to the petitioner.
Okay.
Lady who is 64 years, 63 years.
64 years now.
64 years. So kindly instruct, if you have to record, you record the statement if you want more. She is ready to participate in the VC again and again also.
True VC.
But then don't create any trouble. So if it comes to the knowledge of the court, so certain order may pass. So that way you proceed with your investigation normally and have the statement recorded. Normally it used to be 161 if has already recorded. Probably I think if he has any other query, can call also. One more VC can be arranged. See, allow her.
Yes.
Ask her also to participate in the VC.
Lordship.
But then don't cause any harassment. Okay.
From what I have heard from my client, the call is not very appropriate. So, not very appropriate from the IO.
Okay.
Not in a very polite way.
See.
That is why,
So-
or else this honorable court can at least stay the proceeding in respect of my client, Lordship.
No, they
Stay the proceedings, at least in respect of my client. Since her statement has been given on 166, Lordship, before the IO. And what I've been told is that
the investigation we
the
can't.
investigation
We can't stay.
in
How
respect
do
of,
we interfere with the investigation? We can't.
so
But
Lordship,
actually
if in that case, then if my direction may be passed by this honorable court, not to harass my client, lordship. She has been receiving multiple calls. And lordship, one more thing, the petitioner as well as the respondent too, that is the university. The the petitioner is coming forward with a solution to at least settle between the parties amicably.
Affidavit
Yes,
in opposition,
Yes,
coming
Lord.
forward some solution.
yes, lordship, because
And you are agreeable to that? or
yes, yes.
Likely to.
In fact,
Okay.
the petitioner is proposing for a
Also,
solution.
Mr.
So in that case, if
Gandhi.
so, this honorable court can pass appropriate orders, lordship.
For the state, Lana PP for the state, and Mr.
Takalo.
for respondent number 2,
Yes.
and Miss
Mr. Chila Jamil.
for respondent number 3. Stop, huh? Para. Lana counsel for the petitioner, Mr. Pasito Potesami said he has just received the affidavit in opposition filed by the respondent number 2, where the respondent has come out with some solution.
Yes, lordship,
Or
we are proposing,
Uh,
lordship.
Come out
The
with some
petition is
proposal
proposing.
for settlement. Settlement. And for which he requires some time to go through and to obtain necessary instruction from his client. So, Mr. The Lana counsel for the petitioner also submits that although the parties are in the process of settlement, the IO of the case is causing trouble to the petitioner by repeatedly calling inappropriately. Hence, pray for necessary orders. Stop. Orders preventing,
Lordship, unless it's for investigation purpose.
Hence insist for, hence your prayer is already there, I think, for
Yes, for interim I've prayed, lordship.
hence insisting for the interim order, huh? Start. Let us see your interim prayer. Where is it?
Lordship, interim prayer is at page 30. Page 29, lordship. Page 29, B. Pass at interim order or ex parte order directing the proceedings of GR 276
okay.
to entry
In view of the above, huh?
state.
In view of the above, in view of the above, no any coercive action should be initiated against in view of the above, huh? And in the meantime, during the pendency, not during the, in view of in the interim, it is provided that no coercive action shall be initiated against a petitioner till the next date. Huh?
Lordship,
Okay.
highly obliged.
So just instruct, no order, I'm passing notes and no anyone, huh? Okay, so, is prayed for, release this matter after
3 weeks, lordship.
3 weeks.
3 weeks.
So you are also praying for 3 weeks?
Yes.
Okay.
Bless my lord, highly obliged.
For admission, item number 12.
Item? Okay.
Item 12, my lord. On the last occasion, the state respondent has been seeking time for 2 weeks' time. However, no reply has come forth, my lord. If such is the case, my lord, might kindly release it for the final hearing. My lord, this is a matter pertains to 2011 regarding the proposed construction of the metro cable in Kohima town.
And this petition is for appointment of?
No, my lord, this is for setting aside the arbitral award.
Okay, setting aside.
Yes, my lord. My lord, the state government,
The
as far as
respondents are not appearing.
was been appeared by the double AG on last occasion, my lord.
You have taken steps.
Pleadings are completed, my lord.
Completed.
Completed.
They appeared also.
They appeared, my lord. My lord, this is a peculiar case. My lord, what happened is regarding the appointment, I'm constrained to file before this honorable court regarding the appointment of arbitrators. Way back in 2019, they took almost 2 years to even appoint our own arbitrators. Thereafter, my lord, in view of this honorable court direction, the arbitral proceeding has started comments. The state government took time after time playing the delay tactics. The honorable tribunal was constrained to impose costs for not filing the statement of defense. And this is the 4th time the matter has been listed after issuing notice, my lord.
You were to obtain instruction. So, are you filing objection?
No, your lordship, our learned additional.
Additional
AG,
AG
and Tim Song.
was appearing. So where he
I think he's in the court. What?
We might have obtained instructions by now. Mr. K. Luikan Michael, Land Counsel for the petitioner. Mr. K. Luikan, Land Counsel for the petitioner. Okay, Mr. Boyan Chen. So he is in court 1.
Lordship, I don't know the metrics,
Not in the case.
issues of the case. I think he's not available today.
Not
Kim Song
available
is
in
not
the court.
available.
Hmm?
He's not available today.
Okay. Additional government, then a senior government advocate. Some is that in the instant case, Mr. Kim Song is appearing. However, in the Kim Song, then additional AG, Nagaland is appearing. However, he is not available in the court today. So, in view of the above, though we'll fix it again.
Yeah, maybe a week's time, my lord.
Okay, in view of the above, the case stand adjourned. Please this matter after 2 weeks. 2 weeks.
Lordship, I have information that he is coming in Tim Song.
Yes.
So after the
After some
listed
time.
letters.
My lord, any other matter? Okay. So if he doesn't come, so this order will stand, huh? After 2 weeks.
For orders, item number 19.
May I please, Your Lordship?
Yes.
Lordship, respondent number 1 and 2 has been appeared,
Hmm?
but respondent number 3 notice has already been served, and then in the office note, it has been showing that it has been already delivered, but they are not appearing.
Lordship, I'm for respondent 1 and 2.
Respondent number 3 is the driver, Your Lordship.
No, respondent number
3 is the driver.
3 is not appearing.
Yes, he is not appearing.
He is a necessary party.
No, he is not necessary party, Your
Okay.
Lordship.
Then what do we do?
Lordship,
You are for? You are for?
Respondent 1 and 2.
1. You have filed Wakalat Nama?
Yes, Lord.
Okay.
Lordship, let the matter be listed for hearing,
Yes.
and then LCR may be called for.
Not yet called for elsewhere.
No,
Not yet.
no, Your Lordship.
No, the court has been called for. The court not yet received. It's there. Yes, it's there. Third, Ms. Chua Planning Council for the appellant. Also, Mr. Pinti Wapang, Planning Council,
No,
appearing
no
on
more.
behalf of respondent number 1.
1 and 2.
1 and 2. So 3 is not a necessary party.
No, your lordship.
So what do we do? You want the 3 to be struck off? Strike off from the,
Yes, your lordship.
the office note dated 8/8/24. Reflect that the notice upon the respondent number 3 is still awaited. Now, counsel for the petitioner submits that respondent. No, whether the respondent number 3 participated in the trial court, in the tribunal, before the tribunal.
No, your lordship.
Submits that the respondent number 3. This is against the insurance.
Yes, your lord.
Well, you are.
I'm for the insurance.
And this is against the
Clean.
quantum.
Yes, your lordship.
Okay. The respondent number 3, driver of the offending vehicle, did not participate in the tribunal. Did not participate in the trial before the tribunal. And as such, he is not a necessary party. And hence pray for striking off the name of the respondent number 3 from the appeal. So the prayer is allowed. Let the name of the respondent number 3. Mohammed Firoz Khan, within bracket driver, the strike off from the ghost title at the risk of the appellant staff. Is prayed. So it can be fixed for hearing.
The LCR may be called for.
LCR is already
Okay.
given. Okay. Since the LCR has already been received, let this matter be listed for hearing after
Okay.
4 weeks.
Lordship.
Okay.
Obliged.
I love you.
4 weeks. Yes.
For orders, item number 20.
No.
That's a very same thing.
Your lordship,
Yes.
in this contempt petition, I am for respondent number 1. That is the director, higher education, Nagaland. This relates to regularization of a night chowkidar in Fazal Ali College, Mugokchong.
And
Fazal Ali College, Common College.
Okay.
Fazal Ali Common College
Okay.
in Mugokchong, Mugokchong.
Hmm.
Now, in the writ petition, they have embedded the director, higher education and principal Fazal Ali Common College, Mugokchong as party respondents. So because of the non-regularization of the night chowkidar in the college, they have come up with the present contempt. Now, insofar as my side has been concerned as a director, I have processed the file. And then, but because of an observation, which is given by when I process, it has to process through the PNR department, Personnel and Administrative Reforms Department, which is the nodal for regularization matters. Now, when I process in compliance with the order and direction of this Honorable High Court, your lordship may kindly peruse this. Lordship, this is relevant. May I read, Your Lordship?
Yes, please.
Personnel and Administrative Reforms Department, Organization and Method Branch. The matter has been re-examined and the Higher and Technical Education Department is informed that in absence of the district level verification committee report, it may not be feasible to regularize the casual service up to by Yapang, retired night jogger under the Mazali College motion. So Ichabayarong is the petitioner here, Your Lordship. Number two, moreover, it is observed that the official has already been retired from service and there is no guidelines for ex post facto regularization of service. He has been already, petitioner has already been retired. That is the second observation, Lordship. Number three, in view of the fact stated above, we regret our inability to regularize the casual service of.
Well, what about the direction? Anyway, you file in affidavit then, in that case. File in affidavit,
Lordship.
okay.
Lordship.
So since you have received the instruction.
Lordship.
Okay. Okay. Mr.
And Lordship, as far as respondent number two has been concerned, my learned friend.
You have also received instruction.
Lordship, in fact, the instruction is not the respondent number one. Respondent, so Lordship.
Okay.
Since we have already processed the file to the authority, higher authority. So it will not be.
I'll file the affidavit, Your Lordship.
Okay, file in affidavit form. Mr. Which name? Your name was?
Nisukachi, Lordship. Nisukachi, Lordship.
Okay, Oh, Nisuka Chishi, ne?
Yes, Lordship.
Nisuka Chishi. Then counsel for a petitioner. Staff also had Mr. Muan Chen for.
Respondent number one.
Senior government advocate appearing on behalf of the respondent number one. And Mr. Zimomi for respondent number two. Staff. The Land Council for the respondent submits that he has received an instruction and prays for some time to file in affidavit form to prays for some time to bring it on record by filing in affidavit in opposition stuff. Prays for 2 weeks time, to bring it on record by filing in affidavit form. The prayer is allowed. This is made after 2 weeks.
Pleasure.
For orders, item number
So I
22.
think, Oh, is it okay? So, how many matters are there? 4. Urgency matter there. Urgency, any long matter?
Item number 18 has not been.
18.
Yes.
Whether the other side is present.
No, I understood they will appear through VC, probably.
Okay.
Your Lordship otherwise had fixed the matter for hearing today. I already argued my part on the last occasion.
You're hearing for? Hearing will be done, no?
Your Lordship passed the order that today it will be taken up for hearing.
Today?
Yes.
And the other side is present?
Other side, maybe they are through.
No, no,
They are present.
Okay, this should be listed in the hearing column only.
Yes, Your Lordship.
It ought to have been listed in the hearing column, but then well, that's a mistake by the registry. Otherwise, I came with the understanding that it is.
In view of the above, and age prayed for by the Land Council for the respondent, list the matter on 29 for hearing.
Yes. So today, Your Lordship may take it up. I have come for, my Lord, with that understanding that it will be taken up for hearing.
Okay. So,
let it be taken up in the second half now that. Yes.
At 2 then.
Yes, Lord.
The other matter also, you have 4 other matters, no? We'll resume it too.
Yes. Okay. কোভিডের সময় ক্লিয়ার করে দিয়েছি কোভিডের সময় ক্লিয়ার করে দিয়েছি তোমরা যদি চাপ না দিতে খাওয়া হবে না ক্লিয়ার করা আমাদের কি দল আছে আমি কিছু খাওয়া না আমি একটা হেভি ক্লিয়ার করা না তুই লাগতে কি না আমরা লাগতে কি আমি আমি পড়ে তুমি যদি এটা বাইরে তো এটা বল না টাইম বন্ধ হয়ে যাবে না আসলে আমি আজকে ছাপতে চাইছিলাম যদি কোর্ট না দেয় সেটা আলাদা কথা Hello. Hello. Huh? Uh. কি প্যারাগ্রাফ ফোন নাম্বারের প্যারাগ্রাফ তো আছেই ওখানে দেখো খুঁজে দেখো Hello? Yo? Hello? এখানে ধরাচোন কি কৈ আছো তুমি ফোন নাম্বার প্যারাগ্রাফ নাই ফোন নাম্বার প্যারাগ্রাফ দিয়া হয়েছে ধরা এক মিনিট নালাগে হোয়াটসঅ্যাপ কৰিব মই ধৰক মই চাই দি আছো কি পঠাইছে তেতিয়া লম দিয়া নাই নেকি মই তো দি পঠাইছো হা ঠিক আছে ৰাখা এইটো মই আহি লম তাৰপিছত চাম Hello. Which item are you waiting for?
I think 12, half an hour.
Oh.
The other side, that like is coming on this way.
Okay.
Someone has appeared on his behalf and said like he's on his way.
So you will be called up again now. Yes. Wait, the name?
Michael.
Michael. Okay. And yes, sir.
Thank you, sir. The government dispute has been taking time after time.
So you are from the petitioner.
Yes.
Okay.
We are not allowed to argue.
There's also in the need of absolutely. It's now. Good for nine. Petitions. Yes, yes. It's very. That's what I was saying. I mainly the understanding that it will be hard. It will be hard.
No, it's not to go. That's a problem with the state. So what you do now, sir, again, sometimes we give it 500 plus. The problem is timing, we have to get out now. No, it's again common. After purchasing and brought it now, actually, I believe it's still. I feel like it's something like a
Government moves very slow. It's saying everywhere in the state.
I have been with this government, Nagaland government for around 3 years in Supreme Court. As in council. You have access. You support the today. Today. Yes. What to do, sir? This is the commission. In fact, in one matter, this is to do with the one scheme. The department, I have sending instruction, letters of the letters seeking instruction. So that particular gentleman nature, like the court has summoned him. He's like, I'm happy I'll come. He came, he got a nice meeting. And he said, like, it's like a vacation for me, so I'm fine. No. What can you say more? He's an IAS officer.
Division means he got rid of the official work.
Yes.
So that's a vacation for him.
Yeah. This is the attitude. And opposing the private, said they don't do it. We don't, I can't deal with this system. Yes. Now I'm for the state of BP. Now, whatever there is a contrast. Even some of the deputy secretaries or one of the directors, and because I have appeared for the home and then for family, welfare. They used to come to my office and sign it, everything in affidavit, everything is.
Permission was it on? Job and 13.
The northeastern states, all the northeastern.
Permission
states.
will.
Only mentioned to certain extent.
Arbitration?
And Tripura. Almost all the
Arbitration
states are 2 weeks. They're lagging behind.
No, item number 13 to what?
Maybe better.
No, mention you still now, but it was possible.
Was it
been mentioned? Item number 12, 13.
13.
No,
Admission.
Item number 12. It was mentioned.
No. As be costly to Jamalan Dana. As per my costly 12 is first second, and 13 is arbitration.
Little better.
Much better.
I would say much better because you see, even when the petitions are moved, I mean, the petitions are issued with specific dates, instructions do not come. 1 month, 2 months, 3 months, 6 months, maybe a year, instructions are not coming. Put something in the, I mean, better. They don't pull up the papers. So, but still, in contrast, we can say, always say it's really better because the people are also good in number. Sometimes people are also there.
I know, we can.
Since I have been going around in almost all of these systems,
So that's why what I get. Every country, I think Delhi or the Patna or Kolkata, things move so fast. Whenever it comes to Northeast, that's very slow paced. And then this attitude of not clearing up bills. That's why, they don't get people who are motivated. You appear on a couple of occasions and if you don't get the bills in time. No motivation, good motivation. Morally down. Yeah, morally down. Down. Yeah, after doing this, after doing this. And that's why it reflects in the performance. This morning only, the Deputy Solicitor General of India, we have confirmed over. In few matters, business lending, he is appealing for enforcement directive. Now, Deputy Solicitor General's fee structure is fixed by the central government. Everywhere, it's same fee structure. All India. It's same fee structure. So he was lamenting, he was telling me, I raised my bills 1.5 years, I have been coming over here. I raised my bills at the rate which is payable to me because the government in India has given the rate. They are not even paying me that. The ED is not even paying me that, and there is no explanation why my bills are not being paid at that rate. So I said that take care of the grief, get some other relation here. Like on your time. So how do you manage to reach to, I didn't say that Sezuma or something like that. Yes. I took that road from Dimapur. After Dimapur, I came on a flight. Yes. Thereafter, I basically I don't know about it. The road conditions are very bad. Very bad. In the middle of the road, in the 10 mile. Not that 10 mile road. Yes. Very good. My brother has to come and rescue me. He has to bring all the mechanic. You see, I'm ready to you have to put all the amount of you have to start from the bottom of the with the government. But if you know, it means visual no risk. But when you get the 10 mile, but down there, you have to change the level. All that you have to do. You have to do all the traffic. All the traffic. Do you practice here or at Delhi? Delhi, sir. Mostly. Mostly at Delhi. Yes. If you find it difficult shuttling between two cities. And now I used to travel even to Kolkata, even to Hyderabad, some metros, representing different companies. You work for some solicitor, or what? No. I have a firm with one of my senior colleagues. Okay. Yeah, we have a firm. It's called Enbang Legal. It's a French word for house. Yes. Okay. It's a solicitor firm. Yes, yes. 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 But mostly we get matters from South Metro City. From South. No, I just sometimes imagine if you had got this function from this premises from the one day or the other. Yeah, it's still under construction, sir. No, construction is already completed. Leave not coming. Yes. That is, I think, yet to start. And furniture offers everything. I don't think if the I thought it's separated. Then it will be anything with that. No, I'm saying that what I now get to hear from people of Meghalaya, maybe advocates of Meghalaya, or advocates of Manipur, or advocates of Tripura, all are saying that little did we know that we will end up in this situation. We really regret being separated. If that is what they say. Yes. Yes, day before yesterday, okay, I come from Shillong. Okay. Today is 29. 27th, I had a meeting in Shillong. So I met the
President of the party, there. In Meghalaya. So he was telling me.
Means the functioning is not smooth.
No, man. He was just saying that, why did I sign that letter? Asking for his vote. Because it was a resolution from the Meghalaya bar. That Meghalaya should have a separate state. But now they are benefit. Yes, the benefit of the common network is that you get the judges rotated. You get the judges rotated. This judge next week, some other judge next week.
Yes.
Get the rotation.
That's a media.
The moment you have,
Yes.
separate network, there is something number, you are seeing number, yes. That's sounds good. You have to face the same man for not 10 years.
Yes.
So if For admission, item number 12.
May I please, Your Lordship. Sorry to interrupt, but I'd like to mention for listing of contempt matter for tomorrow, Lordship. We have
Mention, you can make it before the senior bench. Mention always, not before the junior bench, huh?
Yeah, British Lordship, Your Lordship, I tender my apology because on the first half, I have some personal problem.
Okay.
I could not appear the court.
Okay.
Your Lordship, here in this matter, I am yet to receive an instruction from the department. So
Item?
I'm
Item
not,
12,
yes,
my lord.
I'm yet to receive instruction from the
Okay, so
department.
in that case, so Mr. His presence, huh? Mua and Chen remove that one, that line, okay? So hard both, huh?
My lord, my technical report as last opportunity may be granted to the state respondent.
Additional advocate general, no? Okay, so who submits that he is yet to receive necessary instruction? This is respondent is government, necessary
Yes,
instruction,
yes.
huh? And prays for some more time. Stuff, huh? The additional advocate general is given for the 3 weeks time as a last chance to obtain necessary instruction. Okay. List this matter after 3 weeks. Okay.
For orders, item number
Granted for the 3
22.
weeks time. Yes, item? 22.
May I bless your lordship?
Yes.
I'm appearing on behalf of my senior, Mr. Supongwati. Since the respondent are not appearing, I pray the matter be listed after a week.
Okay. Miss, you are Achula. You are?
Sigmo.
Okay, appearing on Land Council, appearing on behalf of Mr. Supongwati Land Council for the petitioner staff. The office note dated 2/7/2024 reflect that the service upon the respondent respondents are still awaited in view of the above. List is matter after 3 weeks. Okay.
Bless your lordship.
For orders, item number 23.
Lordship, as per the order dated 37/24, notice is issued to all the respondents, but notice upon respondent 3 has been returned. So kindly allow us to reissue notice upon respondent number 3.
Okay, your miss.
Address K Lilisu.
Your miss.
K Lilisu.
Land Council for the petitioner. No, hard Miss Land Council. So Miss so Land Council for the petitioner. Also Mr. Yangami Land Council for appearing on behalf of the respondent. Staff, huh? The office note dated. In view of the office note dated 3/8/2024, the Land Council for the petitioner prays for allowing her to take fresh steps upon
Respondent number 3.
Respondent number 3. The prayer is allowed. Staff, step be taken within a week from today
Yes, Lordship.
by a registered post with 80 staff. List is matter after
Lordship, there is an interim.
3 weeks. 3 weeks. Okay. In the sorry, the interim order pass earlier shall continue till the next date. Okay.
Much obliged.
Yes.
For hearing, item number 18. The Lordship. The other day, I already placed the facts. And I also submitted the decisions that I'd be relying on in of the appeal. Now, just to recapitulate, my lord, the facts once again. My lord, the plaintiff is the appellant in the case here.
Plaintiff?
Yes, plaintiff is the appellant in this case. Now, plaintiff had filed a suit before the court below, seeking various reliefs, my lord, and amongst the reliefs, my lord, the prominent ones were with regard to,
The plaintiff, the appellant is a plaintiff
yes,
in the trial court.
appellant is the plaintiff in the trial court.
Okay,
And the suit was filed, my lord, seeking various reliefs regarding a declaration, seeking declaratory reliefs, also seeking permanent injunction, and etc. Now, in the plaint, my lord,
this is first appeal.
this first appeal.
Okay.
Now, the defendants, they filed an application under Order 7, Rule 11.
Order 7, Rule 11.
Rule 11, seeking a relief of rejection of plaint.
Okay.
Now, Order 7, Rule 11 visualizes various aspects, my lord, on which various eventualities, my lord, on which an application for rejection of plaint can be filed and which can be considered by the trial court. Now, the basic ground on which, my lord, this application for rejection of plaint was filed by the respondents.
Just a minute, for my understanding. Yes.
So they filed an application for rejection of plaint. And the ground on which they sought rejection is Order 7, Rule 11D.
Yes. Okay.
Now, if your lordship will consider their application, my lord, their application basically says that the suit which was filed by the plaintiff appellant.
The application is that? This is okay.
Lordship has got the application.
No. Title two.
Yes, the application is at page 208.
208.
Yes. Has your lordship got it, my lord? 208 is the application filed by them.
Yeah.
Now, this is an application on the title your lordship will find that it's an application under Order 7, Rule 11D.
Yes.
For rejection of plaint.
Yes.
Now, in the body of the application, my lord, the grounds are stated in paragraph 3, page 210.
Yes.
Paragraph 3, the petitioners state that on a plain reading of the facts contained
Para 3. Yes.
On a plain reading of the facts contained in the plaint and the documents filed and impugned by him would clearly establish that the title suit of the respondent plaintiff is hit by the provision of Order 7, Rule 11D and Section 151 CPC inter alia on the following grounds. Now, 151, my lord, 151 by itself is not a ground for rejection of plaint. My lord, 151, your lordship knows it's the inherent power of the civil code. So basically, this is an application under 7.1D. Now, 7.1D, if I can take your lordship a moment, that day also, my lord, I had cited 11.1D says, if your lordship will kindly take the CPC, Civil Procedure Code. If your lordship will kindly have the Order 7, Rule 11. Order 7, Rule 11 deals with rejection of plaint.
Yes.
Rejection of plaint, the plaint shall be rejected in the following cases. Now, A, B, C, D, there are eventualities. The respondents filed the application under D. D says where the suit appears from the statement in the plaint to be barred by any law. Now, their contention before the trial court was that my suit was barred by some law. Now, what is that law, my lord? That is spelled out in paragraph 211. Sorry, page 211, the next page. About third line from the top.
Which one?
Page 211.
Yes.
About third line from top, the respondent
Page
plaintiff.
1 para.
Ground. Ground. It's a continuation of ground A, my lord. The third line from top.
Yes.
The respondent plaintiff also reflected that the same order has been taken as one of the cause of action for filing the title suit. Under the provisions of Assam Land Revenue Regulation 1886, certain types of disputes are exempted from the cognizance of the civil court. The issue in regard to the validity or effect of any settlement cannot be questioned before the civil court under the provision of Regulation 1886. Since the order number so-and-so is purely a settlement order made in favor of Jami Masjid Committee and its validity has been questioned by the respondent plaintiff in civil court, the title suit of the respondent plaintiff is barred by Order 7 Rule 11D under of CPC as well as by the provision of the Regulation 1886. Now, this is the only contention that the regulation of 1886, the Assam Land Revenue Regulation, that bars the court, bars the suit. Am I clear, Lordship? That is the contention of the respondents in the application. That Assam Land Revenue Regulation bars the suit. Since in the suit, my lord, I have challenged a settlement order. Therefore, it is barred under Assam Land Revenue Regulation 1886.
Okay.
That is their contention. So, my lord, two things are appearing from the facts till now. First of all, it's an application under Order 7 Rule 11D. And the bar of the law as pleaded is the law of Assam Land Revenue Regulation. Now, kindly see, my lord, how the trial court has dealt with this issue. The trial court's order starts from page 250, but the operative part, the first paragraph, page 251, your lordship may kindly see.
251. Okay, just a minute. Yes, 251.
Yes. The applicants, defendants filed this application under Order 7 Rule 11A.
Oh. Yes,
The
yes.
application is under D, but the trial court proceeds on the premise that it's an application under Rule 11A. Now, Rule 11A is entirely a different thing, Lord. It speaks about cause of action. So naturally, my lord, the case of the plaintiff defendants were not that my suit does not disclose a cause of action. The case of the plaintiff defendants were that my suit is barred under Assam Land Revenue Regulation. But the trial court has proceeded in the impugned order entirely from a wrong premise that it's an application under Rule 11A. So this is the first illegality, my lord, in the approach of the trial court. Now, if your lordship will kindly go to the next page, which is at page 253. Sorry, 254, 255, your lordship will find that the trial court has directly come to the conclusion that my suit is barred. But under what law the suit is barred? There is no discussion.
Where,
255, your lordship will kindly see. The sentence starts from the pre-page. The paragraph starts from page 254. Further, the last paragraph, further,
Yes.
it is annexed that
Yeah.
the respondent plaintiff has paid thou tax on so-and-so for the period so-and-so at office of Mojadar so-and-so for the purported suit land in question amounting to rupees so-and-so. After the additional Deputy Commissioner Dimapur, Nagaland had ordered all the mutation partitions granted in Dag number so-and-so was ordered cancelled and corrected the mutation order Dag number so-and-so and record changed into the name of Jami Masjid Wahid order number so-and-so and issued Jamabandi Patta number so-and-so to the Jami Masjid committee. Despite all these, the concerned Mojadar has collected thou tax from the respondent plaintiff. After this, the respondent plaintiff applied for survey and demarcation of the scheduled land covered dated so-and-so, reflect highly questionable function of such authority.
Where are we reading?
Page 255.
Yes, I lost this.
Yes. It is as it is not only to collect revenues by hook and crook, but it is their bounden duty to assist the public to mobilize legal revenues which are in the district revenue record only. Therefore, on the face of record, well, this is the finding of the trial court. Therefore, on the face of the record, there is no title document of the respondent plaintiff. Now, title document is not a question which the respondents had set up as a ground for rejection of plaint. And otherwise also, my lord, the question of proving or disproving the case will arise only when, my lord, the
finding is therefore on the face of the record.
There is no title document of the respondent plaintiff. In the present suit, there can be no title dispute as within the cadastral area in Dimapur on the above facts, except where there is an express provision of law to which no such facts pleaded in the instant plaint. My lord, that is not even the case set up by the defendants. The case set up by the defendants was that my suit is barred by certain provisions of law. And what are the provisions of law, my lord? That is not mentioned in the application. Simply said that it is barred under Assam Land Revenue Regulation. Therefore, my lord, the trial court ought to have examined the issue that under which provision of Assam Land Revenue Regulation the suit is barred. There is no discussion at all, my lord, in this judgment. I'll read out the subsequent lines also. The civil court cannot interfere into competence of revenue authorities in allotment of land unless there is a prima facie commission or omission of curtailing a person's rights in view of the above provisions. Now, which provisions? The defendants, my lord, they said my suit is barred under Assam Land Revenue Regulation. Very well. Now, to say that my suit is barred or not maintainable, the trial court is at least required to refer to the provision and say that under this provision, the suit is barred. Am I clear to your lordship, my lord?
So although it says that it's barred by the law mentioned. Assam, yes.
Land Revenue Regulation, but there is no mention of the provision under which provision it is barred.
Okay. The provision not mentioned.
Provision is not mentioned.
So here also they refer that the above provisions, but
yes,
provision not mentioned.
There is no mention of the which provision of the Assam Land Revenue Regulation bars the suit.
Okay.
So my humble and respectful submission at this view of the matter are two, my lord, basically.
Yes.
The first submission is that, my lord, your lordship has seen that it was an application under 11D. So therefore, the trial court ought to have proceeded with the case from the perspective of 11D. But the trial court proceeds on a basis that as if it was an application under 11A. Now, if it is a question of 11D, then where is the question of title coming in between?
Yeah, whether you have filed this. Just a minute. They have filed this application.
Their application is at page 208.
208. Have you filed Objection to that?
Yes, yes, I filed an objection to this, my lord. Your lordship will kindly see my objection. I filed an objection and I took a categorical plea that no provision of Assam Land Revenue Regulation can bar my bar my suit. Your lordship will kindly see my objection. That will be at page. That will start from page 227. My objection, your lordship will find from page 227. Has your lordship got it, my lord? Page 227 is my objection.
Yes.
Now, I filed a detailed objection saying that their application under order 7, rule 1D is not maintainable. Because no provision of the Assam Land Revenue Regulation can bar the suit.
This synopsis is also in objection.
Yes, synopsis is also part of the objection. My lord, the objection starts from basically page 232.
Yes. So here you also have mentioned.
Yes.
That it's not barred by.
Yes, your lordship will find, even I referred to certain decisions of this honorable court, page 235, your lordship can kindly come to. Page 235.
Yes.
In paragraph B, my lord, your lordship will see that I have also referred the decisions of this honorable court, based on which I say that my civil suit is not barred. And there is absolutely no discussion of my objection in the impugned judgment. On the face of it, my lord, the impugned judgment does not even give any consideration to the objection taken by me. Therefore, my lord, since, my lord, the applicant said, since the respondents said that my suit is barred under 11D, it was incumbent upon them to show under which provision of the Assam Land Revenue Regulation my suit is barred. Number one.
Where have you stated that it's not barred by this?
Your lordship will kindly come to page 235.
Yes.
Paragraph B.
Yes.
That the contents of para number 3C, D, E, F of CMC number so-and-so is misleading and ill-founded and matter involved with misinterpretation and distortion of the relevant provision of Assam Land Revenue Regulation. That against the illegal and arbitrary settlement and matter in issue involved with illegal constitutional and otherwise established rights shall not be challenged before civil court against the illegal and arbitrary of the settlement officer. In reference to arbitrary above said order number so-and-so, in reference to order number so-and-so, and in regard to order number so-and-so, because the Honorable Competent Civil Court is having jurisdiction under section 39, 154 of the said regulation so-and-so. And accordingly, Honorable Court being competent civil court having jurisdiction and power to pass necessary order and decree, and even to set aside such arbitrary illegal order and empowered with jurisdiction to call the relevant records involved with the matter in issue, and can direct by drawing decree to modify or correct the relevant. And this is the established law, and for the judicial notice of the Honorable Court, herein referred the case laws. Now, therefore, I give the case laws. That on the basis of these case laws, I say that the civil court is having jurisdiction. And the last paragraph, whereon parta permits settlement or allotment of land involving the parties to the disputes and their legal and constitutional rights, including the effect out of the alleged illegal settlement and jurisdiction of the competent civil court was defined, and rules laid down, and which are on the respective matter in issues, is operative and in force, and for the reasons, the instant matter of para number so-and-so of the content so-and-so is not sustainable in law. And in the objection last page 239, your lordship see, kindly see my prayer. In the page 239.
Yes.
In the premises stated above,
it is respectfully prayed before your honor to be pleased allow the matter and for the interest and ends of justice in due course of established procedures kindly dismiss, reject the civil miss case number so and so of the alleged defendant applicants. So this is my prayer. I say that on the face of the judgments and the provisions of law, below the application filed by them are not maintainable. And I want that this application should be dismissed. Now, in the order of the learned trial court, my lord, with greatest respect, my lord, I will submit. There is absolutely no discussion of my defense. Absolutely no discussion of my objection. Trial court simply proceeds on the premise that it is an application under Order 7, Rule 11A, whereas it is not. Therefore, my lord, my humble and respectful submission is this. The order of the learned trial court should be set aside and the matter should go back to the trial court for disposal of the suit on merits.
So, no issues were.
No issues were also framed.
So now what could be the issue here then?
Now, the trial court has to decide, my lord.
So issue can be framed by this court also?
Yes.
To send,
Yes.
So-
Your lordship can also frame the issues.
demand back to decide on issue.
Yes.
Says supposing the issue is to be framed, what would be the issues?
The issue will be, my lord, whether the Assam Land Revenue Regulation bars the suit. That has to be decided by the trial court.
Only one point.
Only one point, because that is the point taken by them.
So, but he decided, but the learned trial court decided on,
Trial court decided on 11A. 11A is not the
11A.
case set up by them. Trial court has to say that under this provision of law, my suit is barred. Because in the last paragraph, which is quite long, starting from page 24 to page 254 to 255, there is absolutely no discussion of the defense taken by me, no discussion of the issue which arises for consideration. And your lordship will kindly see no issues are even framed.
the issue would be whether
Whether the suit is barred under Assam Land Revenue Regulation, and if so, under which provision of Assam Land Revenue Regulation?
okay.
Yeah, because, my lord, if a ground is taken on applicability of law, my lord, then the trial court, and for that matter, every court, my lord, should examine that point by framing an appropriate issue.
So this, the judgment at 250 is on this miscellaneous application only,
Yes, on the miscellaneous application only.
and the main suit is yet to be decided.
No, main suit is decided. My lord, last page, your lordship will see, page 256. Because the miscellaneous application has been allowed, the resultantly, my lord, my suit has also been dismissed. Your lordship will kindly come to page 256, the last page. Because they say, my lord, if I 256,
By the same order, same judgment.
same judgment. But a separate order was passed because, my lord, what happens, my lord, when an application is filed under Order 7, Rule 11, it is registered as a miscellaneous case. as we do here, my lord, as an IA. We, in the High Court, my lord, it is registered as an IA, but in the trial court, it is registered as a miscellaneous case.
Yes.
Now, if the IA is allowed, resultantly, my lord, the main appeal of the case also goes. So here the civil miscellaneous case was allowed.
Yes.
And resultantly, my lord, page 256, your lordship will see the order.
Yes.
In view of CMC 25/10,
Okay.
in connection with this case, disposal, this suit becomes infructuous and is dismissed accordingly.
Yes.
So these two orders, my lord, these two orders are bound to go, my lord. The trial court should decide the order 7 rule 11D application on its merits and give definite findings how it is barred by Assam Land Revenue Regulation.
So, your claim in the plaint.
Yes, my plaint, your lordship will find at page 28.
There has been properly reflected in the judgment and order, your claim.
No, on my plaint, my lord, no judgment has been delivered. Only this order has been passed.
Okay, only on miscase.
Only on
So,
miscase.
Okay, the plaint has not been discussed.
No,
So
nothing.
The plaint file, in this plaint, so you have filed this miscellaneous application. Okay.
Nothing has been discussed.
Nothing has been discussed.
So there,
So your only claim is this then?
my only claim is there for now, before this honorable court in the appeal, my lord. This order by the trial court, these two orders. First order, which is passed in the civil miscellaneous case, page 250. Page 250 order and page 256 order. Page 250 is the order, my lord, which is impugned in the appeal.
Yes, yes.
And page 256 is the subsequent order, my lord, which is also impugned in the appeal.
56 is?
56 is the order, my lord, by which my suit has been dismissed.
Okay.
So these two orders have to go, my lord, and the matter should go back to the trial court.
Okay.
Because of the decision in the miscase, my lord, the suit has also been dismissed as infructuous.
Okay, let us see your plaint.
Plaint is at page 28.
Page 28, your so your claim is basically
Page 28 is the plaint, my lord, and my prayer, your lordship will find at page 45. Page 45 is the relief that I sought in the plaint. Has your lordship got it, my lord?
Yes. Absolutely.
Page 45. So, my lord, there are various reliefs which I have asked for from A to M. My lord, 45 to 47 are the reliefs, my lord, that I asked for in the plaint. So there, my submission is that, my lord, these two orders which I have now shown to your lordship, 250 and 256, these two orders should be set aside and the suit as well as the miscase has to be remanded back to the trial court for fresh decision. Let the trial court say under which provision of law, under which provision of Assam Land Revenue Regulation the suit is barred.
So according to you, so that is the simple.
That is the simple case. That is the simple case, my lord.
Okay, so many prayers.
Yes, so many prayers. My lord, since the reliefs are more in number, therefore, my lord, the volume has become very thick. Then, my lord, the crux of the matter, I am just placing before your lordship the crux of the matter.
Yes.
Because if I can show these two things, my lord, these two contradictions, my lord, I think, my lord, that is enough. Because the respondents filed an application under 11D, not under 11A. But the trial court proceeds that it is an application under 11A. So the entire approach of the trial court was wrong. And since the approach was wrong, my lord, naturally, my lord, there is no discussion as to how it is barred under Assam Land Revenue Regulation. Am I clear to your lordship?
Yes.
That's my submission.
Okay. Yes. May it please your lordship. Am I audible, your lordship? Yes, please. My lord, I am for the respondents 1 to 12. Yes. 1 to 12. And there are other respondents 13 to 20 are not there. Now here, should I proceed, your lordship? Yes, please. Your lordship, my learned colleague has very smartly placed before this honorable court the order of the impugned order of the learned court below. Here my learned colleague has jumped from page 253 to 255 without referring the para 254 where the crux of the case lies. Your lordship, yes. I beg to take your lordship page 254. And I want to go through the impugned order, otherwise it will not be clear, your lordship. Yes. Yes. I should go whole judgment on order. Okay. Now page 251 starts, your lordship. Yes. The judgment order. The applicant defendants filed application under Order 7, Rule 1A, read with Section 151 of the Code of Civil Procedure 1908 for rejection of the plaint in the title suit number 1/10. The brief of the applications arising out of the said title suit 1/10 is that the respondent plaintiff filed the said title suit for declaration of right and title over a plot of land within the north side of block number 203 of the block number 6 of Dimapur town, relying on a permit dated 20/2/1963 purportedly issued by Assistant Commissioner Dimapur, wherein it mentioned of Dimapur Bazaar. The respondent plaintiff averred the state said permit is a grant under the Assam Assessment of Revenue Free Wasteland Grant Act 1948 and paying the Dow house tax thereby. The applicant praised for rejection of the plaint on non-disclosure of cause of action, as the respondent plaintiff has neither pleaded the material facts that the suit land in the instant case is pertaining to the purported grant under the Assam Assessment of Revenue Free Wasteland Grant Act 1948, nor essential component to constitute the facts to prove the case, such as 1. Entry of an estate in the Deputy Commissioner's Register of Revenue Free Estate as a separate grant. Roman 2. The issue of an assessment roll Jamabandi. Number 3. The record of the rates assessed on such estate. Finally, the validity of a settlement granted by the competent authority and the formation entries in the record of rights in consequence of such settlement cannot be challenged before the civil court under section 154(1)(a) and C of the regulation 1886. Now, considering the submission of the respondent plaintiff to reject the application on the ground of under the rules of administration of justice and police Nagaland 1937, there is no scope of Order 7, Rule 11D of Code of Civil Procedure 1908, as it envisages framing of issues of facts and law and to decide the case. It is true that the Code of Civil Procedure Code 1908 is applicable in the spirit only, not in letters, in the state of Nagaland, wherein it means where the procedures are lacking in the rules of administration of justice and police in Nagaland 1937, the Code of Civil Procedure 1908 applies as a guide to resolve or adjudicate the disputes. Just a minute.
Yes, please.
This is dated.
This is dated impugned order, your lordship. 17. This is 29/4/2011.
2011.
Impugn judgment, impugn order.
Yes, yes,
That is prior to the division bench judgment.
yes, that is why.
252. And otherwise, your lordship, prior to that, in Rotan Singh case 1967, the Honorable Apex Court has held that it is a procedural law. Procedural law is applicable in, though CPC and CRP was not applicable in the state of Nagaland by virtue of spirit, procedural law, it is applicable. In Rota, I will come later on to that, your lordship. Now, your lordship, we are in page number 252, your lordship.
252.
Yes, your lordship. Because there is paging also, there are difference from here and there. Now we are in 252. 252.
Yes.
Considering the submission of the respondent plaintiff to reject the application on the ground of, I mean 252, your lordship.
Oh, yes. Yes. Again, okay.
Considering the submission of the respondent plaintiff to reject the application on the ground of under the rules of administration of justice and police in Nagaland 1937, there is no scope of Order 7 Rule 11D of Code of Civil Procedure 1908, as it envisages framing of issues of facts and law and to decide the case. It is true that the Code of Civil Procedure 1908 is applicable in the spirit only, not in letters, in the state of Nagaland, wherein it means where the procedures are lacking in the rules of administration of justice and police in Nagaland 1937, the Code of Civil Procedure 1908 applies as a guide to resolve or adjudicate the dispute, although strict procedures may not enforce. Therefore, rejection of the application on the ground of application of the Code of Civil Procedure 1908 cannot be sustained or overlooked, as it is a public policy to avoid unnecessary litigation. Besides, the applicant's defendants counsel has rightly pointed out that the trial court can exercise its power under Order 7 Rule 11 at any stage of the suit before registering the plaint or after issuing of summons to the defendant at any time before the conclusion of the trial. And for the said purpose, the averments in the plaint are germane, and the pleas taken by the defendant in the written statement would be wholly irrelevant at the stage was relied on the Honorable Supreme Court of India decision held in Salimbai and others versus State of Maharashtra and others 2003 1 SCC 557. Therefore, the respondent plaintiff contention has no merit and the instant application is sustained. Secondly, the respondent plaintiff contention of none of the pro forma defendants had appeared despite of summons served and objection to accept the prayer of the applicant defendants in their absence cannot be sustained. Thus, here, your lordship, I beg to take your lordship to one point that here today is also, your lordship, this pro forma is not present, and they have taken the plea in earlier proceeding also. Status of pro forma defendant to assist the court during trial, and therefore, when the plaint can be rejected as its initial stage, the pro forma defendant's appearance should not hinder to dispose the application. Thirdly, the respondent plaintiff further raised the present applicant's defendants has no locus standi to file the present application as Mutawali only has the locus standi under the Waqf Act 1995. The applicant's defendants are impleaded as defendants in the said title suit by the respondent plaintiff, not the Mutawalis under the Waqf Act 1995. So when the respondent plaintiff has not impleaded the necessary party as per the law, the applicant's defendant's name has to strike out, and at the same time, the plaintiff's plaint cannot keep alive without impleadment of necessary party if there is any disclosure of cause of action in the title suit number 1/10. Necessary parties can be impleaded in this petition cannot survive as per the CPC.
Just a minute.
253 in my
53 is repeated. 52 is repeated in 53 also.
Your lordship, like that.
Yes. Okay. Now 254. No, you are not audible.
In my the copy served up on me, it is 253. However, your lordship, the title suit
Number one,
Now am I audible?
yes.
The title suit number 1/10.
Yes. No, you are not audible.
Necessary parties can be pleaded in this present cannot survive as per the CPC. Your Lordship,
No.
in hearing matter, I thought that it is hearing matter. If it would have been in a hearing list, Your Lordship.
No,
This was in order. That is why I have not come. Otherwise, I would have come, Your Lordship.
So where are you now then? You are in
I am in my chamber, Your Lordship. Dimapur.
Dimapur only.
Yes, Your Lordship. I thought it is in order.
Is that all, or you?
Well, I'll have to reply if depending on what he submits, my lord.
No, it becomes difficult then. It will be difficult. Today will not be, in any case, will not be able to complete this way.
Yes, Your Lordship. I will take 3-4 hours. I will take, Your Lordship.
We have only 1 hour left.
Because Your Lordship, the main thing is that, Your Lordship,
he probably
my learned friend has very technically avoided.
Raised from the body
because there are many cases filed on the same issues, Your Lordship.
It appears from
one of the given and same party, same.
So according to you, it's not an only question of that it was the application was filed under 11A.
7 under order 7A.
And but then dealt with by the learned trial court under 11. Sorry, it was to be dealt with by
11D.
11D. But then he has dealt with under 11A. That is not all for you.
No, sir.
Okay.
No, Your Lordship. No, Your Lordship. They initially filed one.
My lord, I can show, my lord, with all respect, my lord, he is just diverting attention. I am placing.
No, Your Lordship.
I can understand.
No,
yes.
Your Lordship has to, by no means of stretching, my lord, he cannot take his case beyond what is what he filed before the trial.
It appears.
Yes, his application was under 11D.
Yes.
Now 11D, you have to specify what are the grounds. Grounds you have.
No, Your Lordship.
You can.
Your Lordship. Let me finish. Your Lordship, let me finish.
Very difficult.
Let me finish.
Yours.
Let me finish, Your Lordship.
Give you an opportunity. Just wait. Because your presence would be required. It appears. Because there is a gap, and intermittently there is a stop. There is a gap.
Yes, Your Lordship, if Your Lordship is requiring his physical presence.
Required, because he probably is going to raise something else also from the body.
But my lord,
yes, Your Lordship. Page 254 is very much clear.
Lord, if he wants to raise something else also, that else must be within the application filed by him.
Right.
He cannot say anything new.
No. It is not that, Your Lordship.
He has to confine his argument within the application. He cannot go beyond the application.
Within the impugned order, Your Lordship. I am within the impugned order.
His application has to be
one at a time.
My lord, the trial court has to give his finding on his application. Whatever trial court may say hundreds of things in the order, my lord, that will not determine the case. You have filed the application under 11D, and you have to confine your argument within 11D. Now, what he
is raising is that there is no scope of order 7 rule 11D of CPC, and this is because it is apply or applicable in the spirit only, not in letters.
No, I am saying that let it be applied. Although I took a ground before.
And thereafter, what he want to take?
Yes,
have to be heard.
Yes, let the 11D be applied, my lord. I took a ground in the trial court that CPC is not applicable because of the rules of administration of justice. I abandoned that ground. I take it that Order 7 Rule 11D applies. Now, if Order 7 Rule 11D is applicable, what is the ground? Your grounds are stated in your petition. You cannot go beyond your pleading.
Oh, no.
That is enough, my lord. I think we should not discuss anything on that. Now, in your petition, there is no discussion, no averment that under what provision of order, I mean, Assam Land Revenue Regulation, the suit is barred, where from the trial court gives a finding that it is barred under 154. Your petition does
Your
not,
Lordship,
under which
Your
provision of law it is barred. Where from the trial court gives a finding that it is barred under 154. Your Lordship,
it is barred by res judicata, Your Lordship. It is barred by res judicata. There are 3 cases on the same matter of issues.
No, no, no.
They have filed suppressing the factum. They have filed this suit. There are on the same matter.
with all respect, my lord, I'll submit. Res judicata was not a plea submit.
No,
This
no,
was
it was not
set
submitted.
by him.
It was not.
It is in the impugned order, Your Lordship.
Your application was not under for
res judicata.
res judicata.
But it is in the
Anyway, what we'll do,
Your Lordship,
I think the presence of both the party, physical presence would be required because there is there is a gap, and for hearing it will be difficult. So it will rather irritate the parties.
Yes.
So since you are here only at Kohima only, so we can have your presence in the court, physical presence, isn't it? Can you hear? See, he can't.
Yes, yes.
No, his junior is here, my lord.
Now, since he is arguing.
Yes, Your Lordship, I am getting you now. I am getting you.
That's the problem. So
this is the problem. Every now and then.
Let it be this Saturday. Saturday is a working day.
Saturday is working day, but
or Monday.
Matter has already been fixed for Saturday.
Then Monday. Monday, 2nd of September.
No problem. Monday, Your Lordship.
Monday or two. Okay, Monday.
Yes.
Also will do.
Let it be on Monday. I'll have the trouble of coming again, my lord, but then, my lord,
So-
I'll be at your lordship's disposal.
You'll stay Monday.
No, I'll
You
have to
come.
go back. My lord, today I adjourned
Okay.
2 matters before the Chief Justice's court.
See. So at your convenience.
Yes,
I do not have an objection, Your Lordship.
Last time we thought that you both the party will appear.
No, my lord, one thing I must tell your lordship, my lord, something very not very clean with the registry. Despite your lordship's order to list the
There is
matter
a
for
clear
hearing,
order. I don't know why.
the registry and how dare the registry can list it for orders?
In order.
Yes, Your Lordship. This is the confusion, Your Lordship.
Order of the court has to be respected, my lord. Registry
Yes.
cannot fix the items on the cause list. Something.
Order is clear. Order
Yes,
is clear.
your lordship's order is clear, and my learned friend was there. It was at
We'll
his
have to
request.
ask and we'll
That
have
was,
to ask and instruct the registry accordingly. So.
Well, registry
Not at
is,
the moment.
my lord, that is not done.
We'll-
This is not the how the registry should
We need
function.
to get it clear from the registry.
And even if
Okay.
they have some
Anyway, but then since.
confusion, they should ask your lordship's permission. They
Right.
cannot do it unilaterally. Your lordship, it can be taken up on 2nd, my lord.
On 2nd. Okay. Is it okay for you? On 2nd?
Yes, Your Lordship.
2nd is
Monday.
Monday hearing normally which date generally we fix for hearing? In any date? Any date? Okay, Monday, is there any fixed matter? No.
Well, your lordship can only order that it should be listed as the first item in the hearing list. Well, that will come up in the order.
Okay.
It should be listed as the first item in the hearing list.
Yes, Your Lordship.
Both the land council for the parties are present and submitted that this matter has wrongly been listed in order column instead of listing in the hearing column. Stop. And praise for list. Stop. Okay. List this matter again on is prayed for by both the land council for the parties. List this matter again on 2/9/2024. As a first item among in the hearing list. No. Okay.
Lordship.
Much obliged.
Obliged, my lord.
Finish.
Just one thing, one repetition you remember, where you were